After unsuccessfully approaching the registrar, my lord, for fixing this code, this I am mentioning, my lord. Now, this matter pertains to the compensate prayer, appointment prayer of the petitioner. Affidavit has been transacted between two parties, my lord. The matter is not being listed, my lord. Let it come for orders on 22nd August, my lord.
22nd, all right.
May I please see your lordship? Your lordship, I beg to pray for listing of a new writ petition that we have filed on 11 of this month. But your lordship, that the matter relates to the transfer posting, and the labor court, without having a jurisdiction, has rejected my application for maintainability.
Motion,
Yes, your lordship.
18th? 18th?
May it please, your lordship.
Subject to clearance of defects.
Yes. May it please, your lordship. I am praying for listing of a contempt case, my lord. As other two matters are listed on 19, my lord, arising out of same order, my lord. Yeah.
19.
With regards to item number 7, lordships, I am praying for 1 week time. I have informed the other side.
You're for the respondent.
I am for the respondent.
Item 7 will be request made by the council for the respondent, stands deferred. Be listed after 2 weeks. It is submitted that consent of the council for petitioner has been obtained. Yes.
With your lordship, may I pray for listing one item, hearing item, your lordship.
Hearing, what is the matter, subject matter?
Lordship, it was a termination matter. It is a termination matter, and the pleadings, all pleadings are completed. We have approached the registry, but as per last order, it is mentioned that has to come as per usual course. So
usual course it will come.
yes, lordship, but it was a
Which year? Which year?
2024 January he was terminated.
24 January matter.
Any date, lordship.
You listed for orders on 22nd
22nd March,
August
22nd August.
for orders. Do you have a mention memo?
Yes, lordship, I have.
Make it for orders. Listing only for orders. Mentions are only for motion admission orders, not for hearing.
May I please accept?
You may.
Also for listing, my lord, admission matter on 22nd, my lord.
What is the matter?
Madam, relates to promotion, my lord.
Promotion.
Yes, my lord.
27th.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 56, lordship. May be adjourned for with another day, lordship. We have already taken consent, lordship. For the opposite side.
You are for the respondent.
No, lordship. We are for petition.
Petitioner.
Yes, lordship.
What is your name?
Estes.
Counsel for petitioner, praise for and is praise for adjournment of
Lordship,
item 56. Matter stands deferred to be listed after 2 weeks. Yes?
fix the matter on next week, lordship.
No. After 2 weeks. Yes.
May I please, lordship? With the consent of the other side, lordship, I'd like to mention item number 5, lordship.
5.
Lordship, my senior is out of station, lordship.
5-minute hearing is going on.
No.
They have difficulty today. 19th or 21st, Malad, Lord.
Can it be on 21st?
21st, Malad, they agree.
Lordship, can it be on 21st, lordship?
21st. Item number 5.
Lordship.
Based on 21st.
But this is lordship. Also, the concern other side, I beg to mention item number 54. In this matter, records were called for. We haven't received a record yet. Let the matter be taken up next week, lordship.
Lordship, date may be fixed because
Next week, any
the
date, Lord.
petitioner is bedridden, lordship.
54.
54. The records were called for.
29th.
Any other day.
28. 28.
Very well.
Thursday.
Good lordship.
I do, but
Item 54. The request made by the council for the respondent, matter stands deferred to be listed on 28th. Mr. F. Z. Mazumdar is also present for the petitioner, is also present. Yes.
obliged, Lord.
For orders items 1 and 2,
This matter, lordship, today is the matter fixed for delivery of order, lordship.
Do you have the records?
Yes.
Have you marked the records with regard to the proceedings? Is it available?
Once I handed over the records, madam. Again, we were given back.
No, is it, have you flag marked
Yes.
For
the
my
appropriate
purpose.
portion?
আমার ল্যাঙ্গুয়েজের এনার মানে
You do
It
it,
is,
we'll take it up in, we'll dictate it in the second half.
good.
You flag mark it, ask your junior, he'll hand it over to the
That-
court master.
True lordship.
except the record, I think, other things we have clarified, my lord.
Dictates.
At two, my lord.
For admission, part heard item 3.
Grade for employment, that was the matter, my lord, where two dates of date of birth were, my lord, admitted, my lord, initially 56, subsequently 66 by the government.
Lordship, I beg to interrupt. The main counsel is arguing this case on behalf of the Public Works Department. He's on legs in court number 1. His name is Pinag. Can it be taken after some time if possible?
Somebody else should be there. This is a departmental matter. Whoever is
Yes,
there
sir.
should argue.
He's
Finish
more
off.
acquainted with the case, that's why, Lordship.
Huh?
He's more acquainted with the case.
He's more acquainted, but he's not here.
Lordship.
What was the issue?
Two date of births were there, my lord. 156 was, my lord, initially it was incorporated. Subsequently, my lord, 66 at the time of regulation of his service. Enquiry was done, my lord. Another officer, my lord, office clerk, my lord, was engaged, one Manovendra Sharma. Subsequently, what is happened, my lord, 1 year, 2 years more service has been, my lord, all given by the petitioner, my lord, stated to be, my lord. But actually, in fact, his date of birth was 66, my lord. I have already brought the original copy of the, my lord, PAN card, voter ID, my lord, Aadhaar card, and in fact, I card also, my lord. At the time of regulation of his service, everywhere it is 66. But my prayer is that, my lord, as it is recorded as a 56, my lord, his recovery, my lord, order may be, my lord, so far recovery is concerned, it is not permissible as he is a grade 4 employee and there was no false and misrepresentation, my lord, from the side of the petitioner, my lord. As another office bearer was also involved here, my lord, along with in the inquiry report, they have annexed here, my lord. That was filed affidavit opposition by the respondent number 3. In that inquiry report, they have admitted that at the time of initial recruitment, it was recorded as 56. And subsequently, at the time of regulation of his service, his certificate was produced, my lord, 66, 31, 12, 66. So my prayer, my lord, in this regard, I already submitted, my lord, one judgment from this honorable court, my lord. That was fully covered my case, my lord. 21.5 GLT 61, my lord. That is there in the records. So I have seen. Para 20. The notional amount has to be given, my lord, as it was recorded, my lord. 56. Let it be 56 remains, my lord. But his recovery should be stopped, my lord. And so far, my lord, calculation of his retirement and pensionary benefit is concerned, my lord. His actual date of birth, my lord, has to be considered.
Please take us through the judgment. You said it is covered.
Yes, my lord. The death judgment, that is there. 21.5 GLT 61.
Please read.
Death judgment is. Select 2001 GLT. Open 21.
61, GMT, 61.
Apa.
This is only for recovery.
Yes, recovery and notional benefit was given.
This is not there in this judgment.
Two date of birth were there, madam. So earlier was accepted, my lord. Consider and subsequently the amount, the recovery amount was stopped and subsequently payment, repayment, pensionary and retirement benefit calculated from the earlier date. So that period was also considered. And another Supreme Court judgment I have placed there, my lord. There also, my lord, it is.
Why don't you take us through the judgments? Why don't you read the judgments?
Yes, my lord, I am
Judgment
reading this Supreme Court judgment, my lord.
Yes. Which is the one?
Yes, my lord. 2009 3 SCC 117, my lord.
Pandey.
Yes, my lord.
Hmm.
Respondent date of birth, my lord.
Ah.
Paragraph, first I want to read the first paragraph, my lord. Respondent date of birth according to entry made in his matriculation.
Which paragraph?
Yes, paragraph, my lord, 20, my lord.
20.
Yes.
Yes.
It was, my lord, held that recovery sought to be made from this salary of the employee on the ground of.
Paragraph 20 is, please read paragraph 20. Do you have a copy of the SCC?
Yes, my lord. First, my lord, I want to place there, my lord. Currently, first page, my lord. That's place in term, my lord. Respondent's date of birth according to entry made in his matriculation certificate and also entry made in his service book 11 to 1944. According to his entry, his retirement date was 28 to 2002. However, there was another entry in his service book regarding respondent's date of birth according to which his retirement date was 29 to 2004. This entry was made on the basis of affidavit furnished by the respondent, but while doing so, the other entry made on the basis of the matriculation certificate was not deleted. Both the entries coexisted throughout respondent's service. He was allowed to continue in service up to 29 to 2004, and who also paid salary for the period 2028 to 2002 to 29 to 2004. However, later on, salary paid to him beyond 28 to 2002 was recovered on the ground that the respondent had wrongly continued in service beyond his actual retirement date 28 to 2002. The single bench of the High Court dismissed respondent's writ petition, but division bench reversed the decision of the single judge and also directed refund of amount recovered from the respondent. The division bench also found as a fact that there was no allegation against the respondent that he had made any misrepresentation or committed any fraud due to which his date of birth was wrongly entered in the service book. Relying on the finding of the division bench and also affirming the decision of the division bench, the Supreme Court held the appellant should state ought to have deleted the date of birth entered in the service book of the respondent on the basis of his affidavit, as the appellant had already accepted the date of birth of the respondent on the basis of his matriculation certificate. It cannot be conceived of that the authorities could not examine the possibility of two dates of birth entered in the respondent's service book. Since the respondent had worked beyond 2002 without any objection being raised from the appellant's side and the appellant state having got work from respondent, it was not proper at a later stage to make recovery of salary. Even if by mistake higher pay scale was given to the employee without there being misrepresentation or fraud, no recovery can be effected from the retired dues in the monetary benefit available to the employee. It was unfair to make the recovery of salary at the later stage because the respondent might have expected that the second date of birth shown in the service book was accepted by the authorities, and from the reason he was allowed to continue in service and paid salary. However, respondent's retirement benefit may be worked out with reference to his correct retirement date 28/2/2002.
Where is that direction for notional benefit?
That judgment, our High Court judgment I have given, it was
No, in the Supreme Court?
Supreme Court, my lord.
There is a reference to the Pandey judgment
Yes, my lord.
following the guidelines. What are the guidelines?
In that judgment, that was there, Pandey judgment.
Yes.
So petitioners, my lord, benefit may be given, my lord, according to me, my lord.
No, on what basis why are we not referring to the relevant paragraphs of the judgment?
Yes, my lord. Paragraph here, my lord, Pante's judgment
What is your claim? Number one is not to recover.
not to recover.
You are a grade 4.
Grade 4, my lord.
Already it is covered by Masi.
Yes, my lord.
Then
And subsequent, my lord, his date of birth, my lord, has to be, my lord, calculated from the 50, my lord, written from the year 2016 itself. 16 itself, my lord, because, my lord,
your original date of birth was 56.
it was incorporated, but according to me, it is 66.
66.
Yes, my lord. Because, my lord, everywhere it is
So if
recorded.
you are 66, you are still in service.
Yes, my lord, ought to be. But from September 2020, my lord, he has been stopped to work, my lord. From the month of September 2020, he has been stopped. No salary, no retirement benefit. That's why I have to come before you.
There has to be a finding by some authority as to what is your correct date of birth.
Yes, my lord. They have already inquiry report submitted in the
Where is that inquiry report?
Yes, my lord. That is, my lord, page in the affidavit filed by the respondent number 3, page 41, my lord. They recorded both. Page 41.
41.
Yes, my lord.
Yes.
Where is the understanding has interested the inquiry into this overstay of the Bolenboro MR labor in service up to July 2020 instead of his due date superannuated date 31/12/16. Following the records submitted by Pradul Chandra Das Sonso, Regional Office of the Executive Engineer PWD Borpeta Sonso has been fully examined. Examination of record. Service book of Bolenboro has been examined. The date of his superannuation has been recorded 31/12/16 and the service book was duly been signed by the then Executive Engineer PWD Borpeta Division. Letter issued Under Secretary to the Government of Assam Public Works Department, while letter dated 30 September 2005 has been duly examined. It has been recorded that his date of joining 27/1985 and date of his superannuation has been recorded 31/12/16. File serial number so and so. School certificate, the date of birth of Bolenboro has been recorded 31/12/1956, issued by the principal, Pakka High Secondary School, Finuga, which is exactly the same as recorded in the service book issued by the then Executive Engineer PWD Borpeta Rural Road Division. According to the recorded facts stated above, Bolenboro was retired 31/12/16 without any ambiguity, but continued his service up to July 2020. See, Bolenboro had been originally at to Patsala Road Division under Borpeta Rural Road Division, but due to reorganization of division and subdivision, etc., the original division and subdivision has been renamed as so and so. The anomalies have been detected during the period of disbursement of salary under the Bhawanipur, Patasarkusi and Sorukhetri TR division. The irregularities have first has been pointed out by the concerned dealing assistant, Mr. Simoti Sonso. On being noticed, the irregularities follow-up action has been initiated by the Executive Engineer PWD Bhawanipur Sonso. A letter dated Sonso asking clarification. The letter to the Executive Engineer PWD Bagbor Borpetra Sonso, file letter dated 2/9/2020. The Executive Engineer.
Is there any finding that your correct date of birth is 66 and not 56?
Well, they have last finding. Just I have to place my last finding. What they have mentioned. Page 42. Page middle, my lord. Page 42. On 1/10/2020, the undersigned held a meeting with so and so and Divan so and so AO, wherein they furnished the following facts with the record after through scrutiny. Copy of the service book, letter issued by the Undersecretary so and so, school certificate of Bolenboro so and so. There have been startling facts produced before the undersigned with the following information. School certificate of Bolenboro, where his date of birth has been recorded 31/12/66, issued by the headmaster, Koyakushi Milon High School on 27/5/2020. Pan card C Bolenboro, where his date of birth has been recorded 31/12/66, issued by the Income Tax Department. Identity card of Bolenboro where his date of birth has been recorded 31/12/66, issued by the Assistant Executive Engineer, PWD Rural Road Division on 16/12/2005, and Assistant Executive Engineer, 5 Subdivision dated 16/6/2020. All these records appear to be clearly manipulated by the concerned dealing assistant Mohananda Sharma in connivance with Bolenboro Master of Labor. The statement furnished by Bolenboro erstwhile MR Labor has been fully examined along with all the relevant record in this regard. As stated in preceding paragraph, see Bolenboro appears to be equally guilty, although he has implicated Manavendra Sharma in this entire episode, leading to huge financial irregularities. It may be specifically mentioned that see Bolenboro was due to retire on 31/12/16 as per the record verified. I have carefully examined the considered facts, relevant records, and circumstances of the matter. In my considered opinion, Mohananda Sharma is prima facie held totally responsible for following Sri Bolenboro to continue to up to work.
No, there is no clear finding that.
Yes.
Then
No clear finding.
you are a grade 4.
A grade 4, my lord.
All right. So we'll apply the Rafiq Masi. There's no fault. There's no finding as on date.
I'm
That-
obliged, Lordship, as at least. So far as Rafiq Masi is concerned, Lordship, in my understanding, Rafiq Masi do not apply in case of overstay, Lordship. It applies only in case of wrong calculation of allowances, salary, etc., etc.
So
And that is clear from paragraph 2 and 3 of Rafiq Masi's
All
judgment
right,
itself.
then we'll apply this judgment Pandey. If you
Pandey
think-
Jagadishwar Prasad. But there were Lordship dispute. In this case, Lordship, if Lordship comes to first service book, clearly written it is 56.
Who's responsible for overstay?
Yes.
It's the authority who has to point out that you are scheduled, you are to retire on so and so date.
No notice.
Lordship may kindly take pension book, Lord.
Yeah.
Pension
Pension rules.
Rule 95, Lordship. Rule 95, Lordship.
95.
Lordship, may kindly see the last 1, 2, 3, 4, 5, 6, 7 lines of that Rule 95, Lordship. If no intimation is, however,
Which one?
last 3, 4, 5, 6, last 7 line, Lordship, of Rule 95. If no intimation is, however, issued to the officer, this shall not in any way change his date of retirement and shall not confer on the government servant any right to remain in service beyond the date on which he is required to retire.
We are not giving him any right.
Yes.
We are only examining the question of recovery after his retirement.
Yes. Now, then
So
in that
In that
situation,
case, you'll have to come to a finding that he is responsible for manipulation of records.
that is there. Manipulation of record, that is there. That is in the year 2020. That is subsequent to his release from service.
Hmm.
Now, Lordship will consider the fact whether his actual date of birth that is written in the service book was known to him or not. It was
How can we consider that?
in that, on
It is
that,
for- There has to be a finding by you. If you think that some forgery, some foul play was there.
no foul play is there. To us, Lordship, no foul play is there. One certificate submitted by the petitioner himself, and on the basis of that certificate, that date, his date of birth was incorporated in the service book.
No, your inquiry report.
Enquiry report subsequent, Lordship will say, we are saying all the documents submitted thereafter, Lordship, subsequently are manipulated by one employee and the petitioner himself. Lordship, it comes to page 42.
If you think that this is the conclusion of the inquiry, then you should have taken recourse to filing necessary complaints before the appropriate authority that why are you allowing your employees to manipulate documents?
No, so far as manipulation is concerned, these manipulations have no connection with the service book. He never applied for correction of his date of birth in the
Never
service book.
applied. Yes.
So it was known to him, he is going to retire on 16, Lordship. Has he ever applied for correction of his date of birth? No.
Yes.
He never applied for correction of his date of birth. So how can he now claim that I should have been retired in the year 2020? I was forcefully, I was forced to
Alright.
retire.
All right, but his overstay merely because Rule 95 says it will not give him a right.
Lordship,
There
he
is
is
some
saying that,
responsibility for the department to show.
no,
that he
on
has
that aspect, Lordship,
retired.
one judgment, Lordship, I would like to place, very recent judgment passed by our division bench, Lordship. Lordship, very basic fact taken care of there, Lordship, whether the person concerned was aware of his actual things or not. But before that, Lordship, if it comes to the school certificate he produced before the authority, that is at page
And
39.
on top of that, there is a judgment of a court in bench.
I'm placing a division bench order, Lordship. It's very recent, Lordship. If Lordship comes to page 39, Lordship, of the affidavit filed by the department, Lordship.
39.
Page 39.
PWD.
Yes, PWD, Lordship.
Yes.
If Lordship comes to page 39, 38, Lordship, this is his date of birth, 31/12/56, Lordship, this is the service board. Next page, Lordship, this is the birth certificate on the basis of which that date was incorporated. And Lordship might kindly sit down below his thumb impression. So it was submitted by himself, he himself.
Hmm.
Now, if he was aware, if he himself submitted this document, and he was aware of his date of birth.
No, but you continue to pay him salary.
No, that
I
is
can
what I'm
understand.
submitting, Lord.
I can understand that the man worked. He claims to have been working but did not receive salary.
Yes.
He's received his salary.
No, receiving salary, that is why, Lordship, if no misrepresentation is there,
That's right.
then he is
Where
entitled
is
to,
the misrepresentation on his behalf?
because he was aware that his date of retirement is
Not
53.
misrepresentation.
This is misrepresentation.
No,
In
how is it
spite of
misrepresentation?
information, Lordship, if he is not doing something, Lordship,
No.
then I'm placing the judgment only, Lordship. One judgment, Lordship.
You are absolutely trying to say that the department has no role here, which means anybody can come and work at any time. Everyone knows when one has been appointed.
No,
one
all the
retired.
judgment, Lordship, be it Traffic Masi, be it Pandey Jagadev, Jishwar Prasad, whatever, Lordship. The only issue remain there, Lordship. If it is not misrepresentation or fraud, then we are not entitled to recover. That is the only principle, Lordship.
Yes.
Lordship, here, issue was different, Lordship. Here, recovery was sought for during the service period, Lordship. And if Lordship comes to...
So tell us the facts. What is there here? What is here?
Here, Lordship, this person is a High Court employee, Lordship. And for some reason, he was given double benefit, Lordship. And when the authority sought for recovering the extra benefit given to him, if resorted to litigation, Lordship. Ultimately, this decision was passed by the division bench on 30/7/2025. And if Lordship comes to page 4, Lordship. Page 4, Lordship. Lordship, it comes to after having noted the trends of judicial decisions. These are all recovery judgment, Lordship. In Sandeep Prasad Unniyal.
This is not how you refer. You refer the judgments properly.
No, page 4, Lordship.
Page 4 is okay. What is the what are the findings of the judgments here?
Second paragraph, Lordship. Second paragraph.
You are reading the second paragraph.
Yes.
There are certain judgments referred.
Yes.
So what are
these are
the ratios in these judgments?
Lordship, all these judgments were taken care of by in the Rafiq Masih judgments, Lordship.
If you have to refer it, you have to refer it. Yes. Anyway, so
after having noted the trends of judicial decisions in so and so reported in the learned single judge was of the view that the appellant would not be entitled to say that the recovery would cause extreme hardship to him. Next paragraph. The appellant was aware that he cannot have double benefits of the pay hike, and he continued to litigate for it.
He's a stenographer, and what are we referring here? Master role.
No, I am on the issue of recovery. Now, if that person was that because of this hardship, lordship, these judgments were referred.
This is not about hardship. This is about a person who has overstayed.
No, so far as recovery is concerned,
Although his claim is that he should have been allowed to continue because of his wrong recording of date of birth, etc. But there is another aspect is his recovery being sought to be made.
that is hardship, because this is not his right. These judgments were passed, lordship, only on equity, lordship, considering the hardship the petitioner might have faced after his retirement. That was the reason. This was not as a matter of right, lordship.
Let us have Rafiq Machine.
I have that.
Yes.
Lordship, generally in case of Rafiq Masi, we go through the, the ultimate paragraphs. Like if lordship comes to paragraph 2 or 3, lordship, today I am not having the judgment. Dear lordship, it has been clearly explained what are the situations in which case the directions passed in judgment in this judgment will apply, and overstay is not there. It has been specifically mentioned the situations in which case that judgment will apply.
How could his salary bill be prepared after his retirement date? Who is responsible for that?
Lordship, if lordship again goes for that inquiry report, lordship. So far as creation of these documents, lordship, one Mahendra Sharma was accused.
What steps have you taken against that person?
That instruction, lordship, I have not taken.
And affidavit file and censure only. But no action against the petitioner.
When you have come to a finding that he is responsible, who's an employee,
Page 56.
Yes, lordship. Annexure 1. It is the second affidavit filed by the department, lordship, page 56. Page 56, lordship.
yes.
This is the action taken against Sri Mahendra Sharma, lordship. Office order
55.
56, lordship.
There is no 56.
Annexure 1.
55. Mark is 55.
That is annexure 1, Lordship.
Censor,
Yeah.
censor only.
No, that.
For a person who, according to you, is responsible for creating all this.
Documents, Lordship. At least action was taken.
After filing.
What do you say regarding the Pandey judgment?
Pandey, Lordship, there were also two birth certificates were there. But Lordship, here that judgment will not apply because still on the date of retirement, Lordship, he never applied for correction of his date of birth. And in that situation, in that judgment, Lordship, at least that situation was there. So far as date of birth is concerned, disputes were there. But in this case, Lordship, till the date of retirement, as per the date recorded in the service book, no dispute was there. All these issues were raised after he has been asked to retire, Lordship. Prior to that, this dispute was not there.
When was the dispute raised first here?
Lordship, when it came to the notice of the authority that he is overstaying, at that point of time, he submitted all these documents. Otherwise, till
So
2006,
then why do you say dispute was not there?
because no application was there for correction of his date of birth.
No. How did the authority come to know that he is overstaying?
Yes. Lordship, in the enquiry report, Lordship, if Lordship comes to the enquiry report,
Inquiry,
that is subsequent, but that is mentioned there,
somebody
Lordship.
has to
One
substitute the
assistant-
inquiry report.
Yes, he pointed out, Lordship. If Lordship comes to page 41, Lordship, second paragraph from bottom, Lordship.
Hmm.
These anomalies have been detected.
See, you read the first line where the undersigned has been entrusted. Who has entrusted?
He is Lordship.
When was this information available to the department that there was overstay?
No, up to 2020, he overstayed. This is a report thereafter, Lordship.
That's right. So why an inquiry report? Who instituted the inquiry?
That is what, Lordship, second paragraph from the bottom, Lordship. The anomalies have been detected during the period of disbursement of salary under the Bhavanipur, Patasarkusian, Porukhetri TR division. The irregularities have first been pointed out by the concerned dealing assistant, Srimati Pragya Das of that division. So thereafter, this inquiry was ordered, Lordship. One more document is there, Lordship, at page 23. Read petition.
The page number 42 subsequent documents were produced by whom?
The petitioner, Lordship.
Doesn't indicate.
Lordship comes to page 23, Lordship, of the read petition. 23 read petition, Lordship.
Yes.
Subject, Lordship, kindly see, regarding your overstay service. It was to the petitioner. Memo number so-and-so, pursuant to the subject cited above, you are asked to appear before the inquiry committee on 7/10/2020 at 11 AM at the office of the Executive Engineer PWD Barpeta Bagpur and Senga Territorial Road Division, Barpeta. This is for favor of your information and consideration. Subject is there.
So therefore, this anomaly was detected,
2020.
So this anomaly ought to have been detected earlier, unless you arrive at a finding that because of manipulations.
Yes.
This
No,
anomaly could not be
manipulation
detected.
came thereafter, Lordship. The story of manipulation was discovered thereafter when he submitted all those documents, Lordship.
Correct, but
No, 2005.
there is no finding as to how the petitioner was allowed to overstay and draw salary.
But even then, Lordship, the situation facts remains there, Lordship. Till 2016, there was no dispute as regards his date of birth. So far as the service book is concerned, he never applied for correction. So at that point of time, so he could have applied, Lordship, as per FR
He
8.
did not apply whatever.
He did not apply.
Did not apply.
So if
He did not apply because.
no, if it is not, if that is the fact, Lordship, today can he be given the benefit subsequent to his retirement date, Lordship? So I am repeatedly, that is why submitting,
The
Lordship.
question of recovery of the amount which you have allowed him to draw.
That is why I am, Lordship, in all these judgments, Lordship, there is only one
You have
principle,
not justified
Lordship.
as to how a man who is deemed to be, ought to have retired, was allowed to overstay and draw the salary for 2 years.
Lordship, there may be situation.
No, not maybe. You
Lordship,
have
so
to-
far,
you have to give us the facts.
it might have been a fault on the part of the department also. It was definitely a fault of the department. But my submission would remain, Lordship, he was aware of.
He may have been aware of.
That is the law, Lordship. That is the law. That is, if it was to your
The
information,
law can't be adverse to one person. Law has to be equally applied.
that is the law that
So
has
the
laid down in Rafiq Asi
employer-
and the Jagadishwar Prasad.
Employer has to come to a finding that yes, this man, he ought to have retired, he is not retired. If there is a manipulation, if there is a forgery, yes.
Manipulation,
It was not-
forgery, at the same time, Lordship, misrepresentation. If in spite of having information,
Where is that evidence of misrepresentation? Even in your inquiry report, it is not there.
no, Lordship,
can't presume
was
it.
there any situation,
We
Lordship?
can't presume it unless you bring it on record.
No.
Bring it on record if you want.
Could there have been any other situation, Lordship?
No presumption.
No, till 2016, Lordship, was there any,
No, sorry.
was it
If you
disputed?
can bring out any material on record, yes, we can take that into note.
Then Lordship will give me 1 day time. Lordship, I will place 3 judgments, Lordship, on that point only.
Judgments will-
Whether,
No. Judgments cannot be relied upon in the absence of facts.
yes.
You give us the facts for 2 years. What was the responsibility of the concerned officers?
Yes.
Examine your records. Tell us what is there.
That is,
How a man
that is-
has
that is-
continued.
that is one aspect, Lordship. That is on the part of the authority, Lordship.
That is the
We
main
failed.
aspect,
We failed to
because
detect.
that will determine whether there was any manipulation by the petitioner in his favor, whether there was
Not
forgery.
just manipulation, Lordship. What I'm saying, misrepresentation also includes not telling the truth, Lordship. You are aware what is your actual date of birth. You are aware what is
Alright,
your,
if you have
should be your-
nothing, then we are closing it. If
Lordship,
there's
on
something
that
that you
point,
want-
Lordship, on that point, Lordship, I will place 2 judgments, Lordship.
What judgments? On what point?
That in spite of having information, if you have not informed the authority, then it amounts to misrepresentation. That judgment, Lordship.
We are closing it. We'll pass orders.
Another judgment that also specifically mentioned, they ought to have taken action against me. One in another case, my lord, I have
No,
quoted
no, no,
bench.
enough of judgments.
Yes.
All of you are placing judgments without the facts.
Yes. I'm sorry.
Firstly, you overstay.
Yes.
You bring
That's
a
okay.
birth certificate of 10 years.
Up to have, my lord, and to the matter, my lord, earlier, my lord, but that is only.
Heard, discourse. We'll pass over.
So I'm free for 1 day time. 1 day, Lord. Just I will take 15 minutes, not much.
The 1 day will amount to 3 days because we are closing from tomorrow.
Yes, Lord. Next day, any day, Lord. 15, 20 minutes.
Boarding, you see.
টকাও বহুত যাব নহয়।
19th.
Lordship.
19th. List on 19th. Enabling the additional AG to address the court on the next day.
Applies.
Mr. D. Bhattacharya, accountant general.
Item 4,
दूसरा क्यों नहीं दिया? आगे दीजिए। हाँ?
May it please your lordship.
Lordship,
The blacksmith matter, your lordship.
Lordship, I have got the order, Lordship. I have placed it.
That,
Lordship,
well, let me refresh a little bit of.
No, you know, blacksmith, electrician.
yes,
Yes.
Lordship.
What I am trying to point out now is that since
You were trained electrically, but you
Yes.
ended up being a blacksmith.
yes, that is what I am trying to point out. Your lordship, we missed one point on that day. Your lordship will kindly take up the So what has happened, your lordship, there were actually two advertisements. That was admitted fact. There were two advertisements. One for the electrician, one for the blacksmith. This person, he applied for both. And I think one else, one or two more. But these are the mainly electrician and blacksmith. So he was thereafter called for the interview. Now, your lordship will see the interview part, the first page 18, where I referred to, he applied for post of blacksmith and also post for electrician. So there are two posts. Apart from that, he also applied for another post or two posts. We are not on that because he has not been selected. Now what has happened? In the admit card, which was issued, he was called for appearing in a written test. Initially, it was a written test for both electrician as well as blacksmith. Both, your lordship. Now, what has happened? He appeared for that written test. Now, what has happened, your lordship? In the result of the written test, there were nobody was selected or no persons were even considered for electrician. And a few persons, like 1 to 4 persons, I don't know what are the qualifications, but 4 persons were selected for blacksmith. The electrician post was not even, your lordship, considered by the authorities. Now, that is one thing. Now, what has happened? In that order of selection, he was selected and was asked to appear for two things. Number one, he has to appear for a skill test. Now, that is where I get the new thing which has come up, skill test. Now, a person who is a blacksmith and a person who is an electrician have, I think, different skills as per me. I don't know both of them, but anyways, it could be different. So they have taken skill test for a person, maybe for an electrician, for a blacksmith. How can he pass, your lordship? And secondly, if he has passed as a blacksmith in a skill test and appointed as a blacksmith, now where is the question of saying that he is not capable? Number one. Or secondly, he must have been in the skill test.
But it is your own. It is admitted by the petitioner that he is not a qualified blacksmith.
No, he is not a qualified. That is what I am saying.
So
there
whether
is
he passes the test or not,
yes,
his basic eligibility is not there.
May not be. That is what I am trying to point out. The skill test for, I don't know, but skill test was taken. He has passed the skill test.
Then the second part was document verification. Documents were verified. Now the question which will come up, your lordship, there are two sides. One is the electrician, one is blacksmith. He should have been appointed as an electrician because nobody has been appointed as an electrician, though the post he was allowed to work was a post of an electrician. That is where I am trying to point out this. He has not caused any fraud. He has not misrepresented. He has not given any other document. He has given the documents of an electrician. He was called for a skill test, maybe of an electrician, maybe of a blacksmith. We don't know that. Secondly, he was qualified on that. And after qualification, he was appointed as a blacksmith. And then, your lordship, these two things have to be taken into mind. Now, they come up saying that it was a mistake. No, you cannot take a benefit of your own mistake. Obviously, you cannot do that. So, what is his wrong, your lordship? You did not appoint anyone as an electrician. There was a post. Advertisement was there. The select list does not show that somebody was appointed as a electrician. So why is not, your lordship's question will be pertinent. Fine. Then why you did not put him as an electrician if he is not qualified as a blacksmith? That question answer will never come because we don't know. That is why I am saying, your lordship, there's two sides. One is that he is a qualified person. Nobody is denying that. Electrician. He applied for that. He was taken a skill test. You put him in a blacksmith and then you allow him to work as an electrician. There was no electrician selected in the select list. And then you say, no, you are terminated because you are not qualified. What is this? After working for a few months, he's got his salary. Your lordship, EF and other things have been opened, everything done. Then with a stroke of a pen, just one line, you just say, no, you are not qualified, go away. This cannot be, your lordship. It's direct hitting his livelihood under section 14 of the Constitution. This is what I'm trying to point. It is not that it's just a mistake, it's oversight, cannot be. You have a skill test of a person who is a qualified electrician. It could be a mistake like he must have been selected as an electrician but appointed as a blacksmith. We don't know that.
Your primary argument was discharge without notice.
Yeah, that is there. That is the primary argument. But when the matter came up, they say we have done it as a mistake and all. That is why I pointed out a mistake can be like oversight or something like that can be there. But they have verified the document not once, twice. And secondly, there was a skill test. What happened to the skill test? They have not brought all these on record. That is why I'm trying to point out. And in fact, by their own document, they said he was being allowed to work as an electrician. And this is the second. That is why I brought out that there was no post of electrician was filled up, though it was advertised. So what happened to that? He must have been appointed as an electrician, but somehow it was written as a blacksmith. That could also be the mistake by the. If we take it that way, the mistake, and then third thing, your lordship, if it is a mistake, I have not done the mistake, but they cannot take the benefit of their own mistake. If they have taken it as a mistake, you have selected me as an electrician, put me as an electrician, correct it. Why should you try, after appointing me and making me work for so many months, and then you just a stroke of a pen without any notice, nothing? Obviously, notice without notice, so that part is already there. That is already there. So this part I'm pointing it out. Earlier, the skill test part I forgot.
Supporting it with some authorities.
That day, your lordship, I have.
No, these authorities are for the first part.
First part.
The second part, are you supporting?
Second part with regard to mistake. I can give one judgment on a mistake. If they have done it on their own mistake, they cannot take the advantage of their own mistake. No, that to judge. That is the judgment of recent judgment, your lordship. Yes, wait, municipal corporation. I can repeat it. This is on the situation in hand, is with the maxim, para 18 of this judgment. This was delivered on May 9, 2024. Citation I'll give later. Para 18.
Yes.
The situation at hand is squarely covered by the Latin maxim nullus commodum, capre, protest the injurious or propri. This means that no man can take advantage of his own wrong. Now, I'll not go beyond that, your lordship. There were some observations by the court. Then your lordship will
It
come.
has to be on the facts. On what facts was it
This
written?
is on the fact that their submission was that it was oversight,
No,
it
in
was
the
a mistake on
in
that.
the judgment. In the judgment.
Yes,
That's
judgment.
Referring. on.
Yes, that is in that case.
This is with regard
This
to it.
is with regard to a person that was exactly the opposite. It was in that case, the person has done the wrong, not the department. So if your lordship read further that this principle was applied by this court in the case of so-and-so, observing as below. In this behalf, Maxim so-and-so, meaning no man can take advantage of his own wrong, squarely stands on the way of avoidance by the respondent and is stopped to plead bar of limitation contained in the section so-and-so. That was in that case. It is the maxim of law recognized and established that no man shall take advantage of his own wrong. And this maxim, which is based on elementary principles, is fully recognized in courts of law and of equity, and indeed admits of illustration from every branch of legal procedure. The reasonableness of the rule being
They
manifold.
operate against you.
No, it cannot be, because I have not done the mistake. They have done the mistake. And secondly, I cannot take advantage of, they have done the mistake and they are taking the advantage. Because why? If I would have taken the advantage by on the basis of the mistake, my appointment has been allowed and somebody else should have been appointed, has not been appointed, then this would have applied against me. But in this case, nobody was applied as an electrician. They did a mistake of putting me as a blacksmith, though I am as an electrician. And in fact, I was allowed to work as an electrician. Now, in that case, it operates in my favor. Yet, I am not the wrongdoer, your lordship. That thing, your lordship, has to be looked into. I am not the wrongdoer. What wrong I have done? Whatever done, they have done it. Wrong, right, whatever it is. It could have been the right decision, but they put me in a wrong post. Maybe that. So, and para 19 also says that.
No, you can't say you are not the wrongdoer entirely, because you are aware
What I am
of the post that you have applied for.
Yes.
You are not qualified.
No, that is true.
Then
but
the
it is not.
the very eligibility for that post you don't have, you admit.
But I am eligible for electrician. I applied for that.
Correct, but this is not a matter for a direction to appoint you as an electrician or
No.
challenging the non-selection to the post of an electrician.
Exactly.
Here is a case where you are appointed as a blacksmith and allowed to work as an electrician, and you have the qualifications of an electrician. But the post was advertised for blacksmith. There was a qualification advertised,
Yes.
specified.
Yes.
You know that you do not satisfy this qualification.
See,
advertisement is very clear.
No, I'm not on that. I'm not on that. I'm just pointing it out that your lordship is very correct. That I have applied for blacksmith and electrician. I have been called for interview for both. It is not that I was called for the blacksmith only. I was called for both. And there was a written test, was a joint written test. It was not a written test separately for a electrician and separately for a blacksmith. So I did not have a role in that initiative.
Therefore, we are asking you, if you have any authority, you can rely on that extent.
That part authority, Composite.
Yes, Mr.
Lordship, the advertisement was purely for blacksmith, Lordship, which he applied.
Then why did
Lordship.
you select an electrician?
Lordship, he was selected, Lordship, but Lordship in the order, which was not fully annexed, Lordship. And the serial number
order?
4, Lordship, I have given it today, Lordship. I received it last evening, Lordship. I have just given it.
What order is this?
This is his appointment order, Lordship.
Hmm.
Lordship, this point number 4, which was not there in the writ petition, Lordship. This point 4, Lordship. The appointee shall also have to furnish a signed undertaking affidavit at the time of joining as I name appointed as designation in the Department of Government of Assam to hereby solemnly
Oh,
affirm.
this would be applicable for somebody where there is no written test selection.
No,
nothing.
Lordship, there is that.
You have advertised.
Yes, Lordship.
You have given the qualifications.
Yes, Lordship.
You have called for these persons to
And
appear
Lordship,
for the
he has
test.
given. Yes, Lordship.
What test did you take?
Lordship, he has given an undertaking, Lordship, that point, Lordship.
His undertaking comes later, but you have proceeded in choosing, screening the candidates. What kind of screening methods you have undertaken?
Lordship,
That
that's,
you don't know the distinction between a blacksmith and an electrician?
but Lordship, even,
And then you appoint him as a blacksmith, but you allow him to perform as an electrician. Somebody is not being, knows that something fishy is going on and is permitting the same to happen.
no, Lordship, immediately when we come to know, Lordship, that we have taken the action,
Exactly
Lordship.
what we are asking you.
And Lordship,
What
there
is
was a
the-
clear
What
mis-
is the point of having a screening test if you can't find out a man having qualifications, not having qualifications?
But Lordship, here in this matter, Lordship, he has given an undertaking that he is.
This undertaking comes later, after appointment,
Yes,
after
Lordship.
selection.
Yes, Lordship.
We are asking you, what have you done for the selection? Was there any selection held?
Yes,
Perhaps
Lordship.
not.
Lordship, that point, Lordship, I'll have to get the specific instruction.
Why don't you get all the instructions? Why do you think the court will allow
Lordship-
you to get instructions after instructions
Lordship,
after
this order
instructions,
was-
8 points?
Lordship, this order was not there in the.
You are
petition.
defending the department.
Yes, Lordship.
You know that there was a selection, there was an advertisement, there was an eligibility, there was a selection process,
Yes, Lordship.
and you choose not to obtain your instructions.
Lordship, regarding skill test, Lordship, that I do not have, but otherwise, Lordship, this order, Lordship, I want to bring this on record and the affidavit which he has given as
No, you
undertaking.
can't bring it on record.
If this judgment, your lordship, another authority that your lordship wanted,
Hmm.
lordship will kindly take a page, para 22 of this judgment. Here, the court has said to both the sides of this here. Para 22. The pristine maxim of fraud as just no quam, prohibitant. Fraud and justice never dwell together, has never lost its temper over the centuries, and it continues to dwell in spirit and body of service law jurisprudence. It is settled law that no legal right in respect of appointment to a said post vests in a candidate who has obtained the employment by fraud, mischief, misrepresentation, or malafide. These are the judgments. Then here comes, it is also settled law that a person appointed erroneously on a post must not reap the benefits of worthy candidates. However, in cases where a wrongful or irregular appointment is made without any mistake on the part of the appointee, and upon discovery of such error or irregularity, the appointee is terminated, this court has taken a sympathetic view in light of various factors, including bona fide of the candidate in such appointment and the length of service of the candidate after such appointment. Now, your lordship will kindly turn to para 27. The conclusions arrive here. Para 27 and 28. Admittedly, in the instant case, the error committed by the respondent board in the manner of evaluation of the answer scripts could not be attributed to the appellants, as they have neither been found to have committed any fraud or misrepresentation in being appointed qua the first merit list, nor has the preparation of erroneous model answer key or the specious result contributed to them. Had the contrary been the case, it would have been justified their ouster upon re-evaluation and deprived them of any sympathy from court irrespective of their length of service. In our considered view, the appellants have successfully undergone training and are efficiently serving the respondent state for more than 3 years, and undoubtedly their termination would not only impinge upon the economic security of the appellants and their dependents, but also adversely affect their careers. This would be highly unjust and grossly unfair to the appellants who are innocent appointees of an erroneous evaluation of answer scripts. However, their continuation in service should neither give any unfair advantage to the appellants or cause undue prejudice to the candidates selected qua the revised merit list. So here, the only difference was that they were irregularly selected, wrongly selected, or erroneously selected, but it was not their fault. Therefore, they were allowed to continue, but it was not on the benefit given to the others who have lost that. So in this case, your lordship, no electrician was selected. That is why I'm saying that they could have converted him from blacksmith to an electrician. In fact, he was allowed to work as a blacksmith because electrician, because they themselves said there was no post of blacksmith.
Is there an electrician post in Where are you working?
At
Tezpur?
Tezpur
Lordship, there
Medical College.
Is there a?
Yeah, that, he
no
was allowed
advertisement.
to work there.
No.
The advertisement was specifically for blacksmith, Lordship.
Hey, we may
Where-
rakha na, mo koi lo boti.
Where are the posts?
Lordship will see page 45. Page 45 of the writ petition. He was working at Tezpur Medical College Hospital. Because there is no blacksmith activity there. It is stated at page 45. Last page of the writ petition. And he was released only on the basis of the order that was on the challenge here on page 44, where nothing has been stated. So this is the reason. And the electrician was never appointed by the selection in both the selections. So this, that is what my case. And I have not done anything wrong, Your Lordship.
How many, where were the blacksmiths appointed?
Lordship,
Was there any appointment made?
No, only
Yes,
one was
Blacksmith or
selected.
electrician?
From that list, only one person was selected, and this is the only person. And the electrician, nobody was selected. The list is there. Select list is there.
Where is that?
That select
Page
list Your
25,
Lordship
Lordship.
will find at page
25, Lordship.
25. In fact, Your Lordship, in the first written tests also, Your Lordship, there was no post for electrician was also not selected. And in page
Were
25,
there
now it
any
is
electricians
24.
selected?
24.
No, Lordship.
No, no,
In
no.
this in this advertisement, there was no post for electrician, Lordship, advertised. Lordship.
No, no, there was
This
two
advertise-
advertisement. That is what I am trying to point
But-
out. And on the last occasion, even he said that there were
Lordship,
two
he
advertisements.
applied, there were 4 advertisements. He applied for 2 advertisements.
So
And
what
Lord-
happened to the other results of the other advertisement?
Lordship, there he was not selected, Lordship. That result, Lordship, we do not have, Lordship.
Lordship, I am trying to point out, kindly read the notice, Your Lordship. Just my learned friend is submitting. Kindly read the notice, Your Lordship.
24.
24. I'll read this 24. This is for information of all concerned that as per approval of the competent authority, candidates with following roll numbers are provisionally selected for grade 3 technical post under the Directorate of number 1, Medical Education, number 2, Directorate of Health Service, number 3, Directorate of Health Service Family Welfare, Assam, and Directorate of AYU, Ayush, Assam, by advertise number so-and-so, 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 all these advertisements, Your Lordship, this is the select list. If he has a separate select list for this advertisement, Your Lordship, ask him to bring it. This is not the way to submit, Your Lordship. He, on the last occasion, we brought the second advertisement
Yes,
and
Lord.
said that, yes, this is also advertisement. Both these advertisement has been taken into
Is there
consideration.
any other select list?
Lordship, that Lordship, I do not know, Lordship. As on today, Lordship, I do not have that instruction, but there were 4 advertisements. He applied for 2 advertisement of,
No, kindly come to 24.
Yes,
Number
Lordship.
24.
yes, Lordship.
It is a notice issued by the DME, DHS.
Lordship, it is, yes.
It refers to all the 4 advertisements.
Lordship, yes, Lordship. It is a notice issued by all the 4 directorates, in fact, Lordship.
Then, so does it include all the results? This is a combined result of all the 4? Or it is only, it appears to be a combined result of all the 4?
Yes, Lordship, it appears, Lordship, but
Then, please clarify and come back and get us the
Yes.
results.
yes, Lordship. And regarding skill test also I'll get, and the undertaking also I'll get, Lordship, which he has given, Lordship.
Tuesday,
Thursday, Lordship, from Tezpur I will have to get,
Thursday,
21st.
counsel for the heard, Mr. Mandan, counsel for the petitioner. And Mr. P. Puman, counsel appearing for the health department. During the course of the hearing, the query was put by the court to be State Council as to whether the notice dated 10/5/2023, which is encloses annexure F to the writ petition and signed and shown to be signed by the Directorates of Health Services, and wherein the advertisements, reference to 4 advertisements are found, contains or reflects the composite result sheet in respect of all the 4 advertisements pertaining to all the 4 directorates? Or is it pertaining, or is it, or does it reflect only a portion of the combined select list, a combined result/select list? Let these instructions be placed by the court, before the court by the respondent counsel. You get it on 19th,
Yes, Lordship.
19th.
Lordship, 21st, Lordship.
No. 21st, our dockets are filled up.
Lordship, then on 20th, Lordship.
20, all right. List on 20.
Lordship.
Item 6.
May I please, your lordship?
Yes.
In this case, my lord, the MOU contained the arbitration clause, my lord. And accordingly, my lord, the notice was also issued, which is at page 171, my lord.
Yes.
Yes, my lord. So, my lord, in terms of the clause 56 of the MOU, my lord, since there is a dispute arose to that effect.
According to you, this is a notice. According to the respondent, this is not a notice. Calling upon
It is an intimation that they are approaching High Court.
for appointment of an arbitrator.
Yes, my lord. Because, my lord, in 2018, this MOU was signed, my lord.
All right.
Thereafter,
We have heard both the councils will pass orders disposed.
Item 8.
highly advised, my lord.
My lord, the petitioner is a transfer matter, my lord. Petitioner is serving as my lord assistant sub inspector, my lord, Frontier Guwahati mine. My lord, as per the my lord, the transfer annual transfer guideline, my lord. Petitioner, my lord, the file a representation, my lord, for 5 choice of place of posting. Accordingly, my lord, the respondent, my lord, they issued a my lord common transfer order on 12 April 2024, where petitioner was transferred to my lord the 67 Battalion, my lord, Lumla, my lord, Arunachal Pradesh. My lord, after that, my lord, on 25 May, my lord, 2024, my lord, one unfortunate incident what happened, my lord, where my lord petitioner was split, my lord, from his native place, my lord, at deployment, staircase. So, my lord, he was severely injured, my lord, fractured, my lord, his backbone, my lord. He was treatment at my initial treatment at deployment, my lord. Then, my lord, the SSB own hospital, my lord, that is page 34, 40, and 55. Then, my lord, what happened, my lord? The respondent authority issued, my lord, subsequent transfer order, my lord. Before that, my lord, he filed a representation, my lord, that is page 64. Instead of, my lord, the 67 Battalion, my lord, the Lumla, my lord, 5 places posting, my lord, that is page 64, my lord. Subsequent, my lord, respondent authority issued, my lord, the subsequent transfer order, my lord. on 26/9/2024, where petitioner was transferred to my lord, 21 Battalion, Bagaha, my lord, Bihar. My lord, being agreed, my lord, petitioner approved before this court, my lord, and this honorable court on 20/12/2024 passed an interim order, my lord. My lord, during the pendency, my lord, the respondent authority, my lord, constituted a medical board, my lord, on my lord 8/1/2025, my lord. Whether my and petitioner appeared, my lord, before the medical board, and this honorable court, my lord, kindly see, my lord, the order dated, my lord, 6/2/2025, my lord. Last line, my lord. Ms. B. Sharma, learned physician, may complete her instruction as regards any medical board and any decision thereof. My lord, accordingly, they filed affidavit, my lord, but they have not annexed the, my lord, the result of the, my lord, medical board. My lord, the petitioner also filed, my lord, a affidavit, my lord, and he undertake, my lord, if, my lord, the respondent authority, my lord, medical board, after examining that he is fit, my lord, then he is ready to go, my lord, any place of, my lord, the country, my lord. Already, my lord, 23 years, my lord, he transferred various places of posting. My lord, on, my lord, the 25/3, my lord, kindly see, my lord, 25/3, the medical board, my lord, after examining, my lord, report that he is not fit, my lord.
Where is that?
Yes, my lord, I have, my lord, after filing, my lord, affidavit, my lord. May I read, my lord?
Yes.
Opinion of the board, my lord. Number 1, findings of the board. Individual in is case of PIVD L5S1 with L5 radiocalopathy and was categorized as S1H1A1P2 T24 E1 on 6/6/2024. On examination, during this board, the individual is not able to walk long distance without support. Gross limping towards right side on walking. No spinal tenderness, no gibbous, no scoliosis, kyphosis, no neurological deficit, SLR right 45 degree and left 70 degrees, neurological consultation dated 9/1/2025, SO L5S1 PIVD with grade 1 listhesis, no advice to continue with physiotherapy and supportive medication. Hence, the individual is not fit to be upgraded, and the board is of opinion that he may be downgraded to S1H1 A1P2 T24 +24 E1 for L5S1 PIVD with grade 1 listhesis. So, my lord, without stick, my lord, walking stick, he cannot move, my lord. So, a petitioner is ready to go from present place of posting, my lord. As per the representation file, my lord, place 64, my lord. 5 places, my lord.
He was posted where? Transferred where?
At present, my lord, transferred, my lord, initially, my lord, 67 Battalion, Lumla, Arunachal Pradesh, my lord. Then, my lord, after this incident, my lord, responded transferred to, my lord, 21 Battalion, my lord, Bagaha, Bihar, my lord. And he filed his representation, my lord, to 5 such a place of posting, my lord. My lord, initially, my lord, he himself, my lord.
Why? What is your difficulty in going to Bihar?
My lord,
your restrictions are no restricted employability at high altitude, 2007 to 2,700 meters or 9,000 feet hilly terrain, extreme cold area. This is the restriction. So Lumla, okay, I can understand.
Yes,
but
yes.
Bihar, where is your problem?
My lord, even my lord, he is not, my lord, their own medical report, my lord.
The medical report, see, it says, come to serial number 10.
Lordship.
Fit for duties not requiring severe stress. So you have not been held to be unfit for duties. You are fit for duties.
But
this is the medical report. You have not been restrained from performing your duties.
my lord, there also, my lord, stated, my lord, avoid forward bending, my lord, weightlifting. My lord.
Right, but these are restrictions, but it doesn't say that you are not fit for duties.
My lord, instead of, my lord, I am, my lord, can you see, my lord, page 64, my lord. I'm ready to go from here, my lord, present.
No, but you don't get the choice to
Only,
determine the places of posting.
My lord, that is, my lord, also transfer guideline norms, my lord.
Hmm,
My lord, kindly see the last paragraph, my lord.
yes.
Number one, my lord, instead of Bagaha, therefore I earnestly requested to your kind honor for consideration of my transfer from 67 Battalion Lumla to any of the following units.
You want it in Assam?
Lordship.
Then?
Lordship, 5 places. My lord.
In Assam,
Yes.
you are a member of the discipline force. You should be ready to go anywhere. Where is the transfer guidelines?
Transfer guideline, my lord, they have also annexed, my lord, in their affidavit, my lord. In their affidavit, my lord, kindly see page 114, my lord. Their affidavit, my lord. And clause 8, my lord, kindly see annual transfers, my lord. Page 115, my
Hmm.
lord.
You are now at which rank?
ASI, my lord, Assistant Sub Inspector. 5 choices will be given by all personnel through ETS.
Hmm.
So accordingly, my lord, petitioner filed his representation to five places.
Where is the impugned transfer order?
Impugned transfer order, my lord, initial order, my lord, page 30, my lord, page 29, my lord. Petitioner's
Name?
page 29, petitioner's number 1 is serial number 919, my lord, page 30, my lord. Then, my lord, 919, page 30. Then, my lord, page 95, my lord. 26 September.
Then?
Petitioner's serial number was, my lord.
No, page number?
Page 95, 96, my lord.
96.
Serial number 36, my lord.
36. So initially you were transferred to Lumla.
67 Lumla, my lord. So then, my lord.
So is it your case that in this place where you are transferred, 21 Battalion,
Lordship,
the medical facilities or treatments are not available?
It's a hard area, my lord. As per their own guideline, my lord. Kindly see, my lord, the location, my lord. They have page, my lord. Page 127, my lord. My lord, 1 to the page 123, my lord. Serial number, my lord, 30, my lord. Page 123, my lord. 21 Battalion, Bagaha, Bihar, my lord, hard area, my lord.
One
123, my lord. Serial number 30, my lord, 30. 21 Battalion, Bagaha, Bihar, hard area, my lord. Posting type, my lord.
Serial number?
30, my lord, 30.
30. How does one distinguish between hard and normal?
Normal, my lord, it's like, my lord, like Frontier Guwahati, my lord, present place of posting, my lord.
Yes, madam.
Lordship, he is in the state of Assam for last from 29/3/2018, at page 107, I have given the chart of his posting, Lordship. Lordship, page 107. So, Lordship, from serial number 5, from is 124th Battalion Rongia from 29/3/2018 till 3/2/2020. And then, Lordship, from 4/2/2020 till date, he is in the Frontier Headquarters, Guwahati. So last more than 5 years, almost 6 years, he is in a state of Assam, Lordship, where his normal tenure is 3 years at Frontier Headquarters. And my learned friend had showed the transfer policy, Lordship. As per that transfer policy, also the tenure, page number 115.
Yes.
Tenure, Lordship, clause 5. All unit and formation 3 years except battalion in high altitude areas of Didihat, Ikusam, Gazing, Rangpo, Tawang 1, Tawang 2, 2 years. On completion of tenure in a unit of a particular frontier, the personnel will be transferred to another frontier. He given his choice of posting that all the 5 places in the state of Assam, Lordship. And
Where is this place? Devendra Nagar?
Devendra Nagar is also in this Sonitpur.
Okay.
So all the 5 places, these are on the same battalion, and this is in the state of Assam.
Considering his medical condition,
He had first given choice posting to 67 Battalion Tawang. During that pendency, Lordship, he had submitted another application that because of that he had met with an accident. Then that area was high altitude area, and his submission is that he is unable to move to a high altitude area. Then also he gave 3 choice posts, but that is all are in state of Assam. So instead of Tawang, we have transferred him to Bihar, Lordship.
he says this is a hard posting as per the list.
Lordship.
So, considering his medical condition,
Lordship.
he has suffered. The medical report is there, which reflects that he is not supposed to do certain things. There are restrictions. So during his posting, would he be required to do any of this?
No, Lordship. That harden normal, it is only the location for the administrative requirement only, Lordship. Tawang was selected as extreme hard because of the high altitude, but now as per his request, we have
He has been asked to avoid handling of weapons in the medical report.
that is not only in hard on normal area, Lordship. That is his service condition on that he may have to follow in because of normal and hard.
Tell us what duties is he assigned to in the place where he is posted, whether it will be contrary to the advice, medical advice.
No, Lordship, because
Where have
his
you
medical evidence, Lordship, that is also that medical evidence, he had first relied on a review medical examination. In our affidavit, we have stated that review medical examination has nothing to do with his posting also. He can do it at any place of posting. And this medical evidence is stated only stress that he fit for duties.
Do you have a copy of this?
Just now he had served.
They have not annexed.
Close serial number 10.
Yes. Fit for duties not requiring severe stress may have restriction in employability at high altitude. That is only may have restriction.
Then
Altitude so and so is hilly terrain and extreme cold areas. Avoid forward bending, weightlifting, running, jumping, crawling, hill climbing, and handling of weapon. So that in a force, what is normal is in the normal area or hard area, nothing. Only that can be avoided, that hill climbing. That we have taken care of, Lordship. But forward bending, weightlifting, no, that may be necessary in a normal.
We'll direct them to ensure that these are adhered to as per the medical. In your place of posting, you will not be allowed to do any of these as reflected in the review medical board at serial number 10.
And serial number 11 also, serial number 13, my lord, next medical board will be, my lord, on my lord 11/7. If my
That is over.
11/7 is already.
But today, my lord, as per my instruction, not my lord examine, my lord.
That
All right, that can be done there also.
yes, that is my affidavit. I have stated that.
That can also be done. You must
My
be
lord,
having.
I have posted my lord, assistant sub inspector, my lord, lordship kindly. My lord, he has specific mention, my lord, not to my lord.
Your grievance is that you suffered some injury, therefore you are not supposed to be posted in the place where you have been transferred.
Lordship.
But show us from any medical report or from any policy that because of the injury you have suffered, you will continue to remain.
My lord, as per the medical report, my lord, they have stated that S1, H1, A1. My lord, on that, my lord, medical region, my lord, the promotion, my lord, not to my lord, one judgment, my lord.
That got to do with transfer.
Yes, my lord. So, my lord, in case of transfer, my lord, they have, my lord, rigid, my lord, that transfer to the petitioner, my lord.
Huh?
My lord. Only my humble prayer, my lord, I'm not to, my lord, continue here, my lord. I'm ready to go, my lord. My lord.
No, why are you apprehending this new place of posting? You tell us that there are this place of posting, you'll be required to do anything contrary to what is specified in serial 10.
My lord, then, my lord, it is, my lord, they may, my lord,
Then why are you apprehending? You are apprehending. You are finding it difficult to accept it and go.
And in the event he face any some difficulty, he may approach there also. There is no
My lord,
difficulty.
in petition, my lord, one of the photo, my lord, also, my lord. Without my lord walking stick, my lord, he cannot move. my lord. Page 103, my lord, kindly see.
We are relying on the medical
Yes,
report you have given us.
Lordship.
This medical report, besides downgrading your medical condition, says you are fit for duties not requiring severe stress. Now, if you think that you are not fit for duties, you are to be bedridden, then you need another review medical.
My lord, recently, my
Now,
lord,
if you cannot walk without support or walking stick, that same feature will, that same hardship you will face in Guwahati also, or in Assam, anywhere else. You have been in Assam for more than 5 years or 6 years.
I'm wrong. Yeah, my lord, it was my lord, Bihar, my lord, last 10 years, my already, my lord, I was transferred to Bihar, my lord, last 10 years, my lord, already.
That we don't find any
My lord,
reason.
I'm not saying, my lord, I'm not to go, my lord.
We cannot, you give us any you make any submission that these transfers are violative of the policy or rules or notification or any judgment. Because transfer and posting is dependent on the employer.
Yes, my lord.
Depending on how they want
Only
to
my
utilize
medical
the-
reason, my lord. Only my medical reason from, my lord, the other 5 places. my
But
lord.
your medical reasons do not say that you are not fit for duties. Medical reason doesn't say that you are required to be restrained in Guwahati or in your home or anything like this. Do you have any, how many family members you've
Yes,
got?
my lord, my daughter, my daughter, my lord, and she's also suffering from mental, my lord.
Where is that?
Yes, my lord, but my lord, she was staying, my lord, in my native place, my lord.
So she is not staying with the petitioner. So
My lord,
there is no
now, my
difference.
lord, is class 10, my lord,
Where?
at Digboy, my lord.
Big boy.
Yes, my lord.
Still staying where? With
Digboy,
whom?
my lord, my native.
Tinchukia.
With whom?
With my wife and my,
So you are not the caregiver.
Yes.
my lord, that is true, my lord. But medically, my lord, I have next, my lord, some documents also. Here is some psychiatric problem, my lord, also. And now, my lord, class 10, my lord.
So, are you the caregiver? You are yourself injured. Will you be in a position to give care to your child by yourself? There's a notification where it says one of the two parents,
Yes,
unless you are the single parent. You are not a single
my
parent.
lord, in this regard, my lord, I have stated my affidavit, my lord, kindly see, my lord.
We don't find any merit, Mr.
Lordship,
Singh.
almost 8 months he is here, Lordship, after this interim order. So it's
Who has
difficult.
relied on the judgment? Naushad Rahman.
I have relied.
To what extent?
24, 25, 26, that in all India services, one cannot have any choice posting, Lordship. And this is also in post, and he is here. No violation, no malified action against him. If he have any difficulty, then he can, regarding his work, then he can submit there also. And this medical board is nothing, he can always have that. If his next review board finds him unfit, then they will definitely give another report also in that condition.
The review, second review, my lord, but not still today, my lord, not conduct, my lord.
Where is it?
My lord, para 13, my lord, kindly see. 11-7, my lord, already, my lord, not.
All right, we'll make it subject to the review to be conducted.
Lordship.
Heard counsel for the party, this petition is filed by the petitioner, putting to challenge the transfer order. 12th April.
12 April, my
12th
initial order.
April, issued by the respondent authorities, transferring assistant sub-inspectors within bracket general GD to the respective units mentioned therein. Name of the petitioner appears at serial number 919. Stop. The petitioner is posted in what is FTR? Frontier?
Frontier headquarters.
Frontier headquarters in Guwahati of the SSB. And he's been transferred by the impugned. He has been transferred by the impugned order to the 67 battalion, which is in Lumla, Arunachal Pradesh. Stop. The petitioner submits that because of an injury he suffered leading to a fracture of his, leading to fracture of
Backbone.
backbone. He represented before the authorities and subsequently the transfer order was modified, and now where is that modified order?
Modified order, my lord, page 95, my lord, 26/9/2024, my lord. Serial number,
Whereby
my lord, page
the earlier transfer order stood modified, and by order dated 26th of September 2024, the petitioner along with others
serial number, my lord,
have been issued transfer orders
21
or modified transfer orders, and the petitioner's name appears at serial number 36 and he is shown to be transferred to 21 battalion instead of 67 battalion. Stop. The learned counsel for the petitioner submits that the 21 battalion at present is posted in
Bagaha, my lord, Bihar.
what is the name of the place?
Bagaha, my lord.
Bagaha.
Bagaha in the state of Bihar. According to the counsel for the petitioner, because of the fracture, he is unable to perform his duties with or walk independently without support of a walking stick. Stop. Counsel for the petitioner has placed before this court the opinion of the Review Medical Board dated 25/3/2025. Stop. Referring to the said medical review board, medical report, learned counsel submits that he has been found to be fit for duties not requiring severe stress. And employability restrictions at high altitude above 2,700 meters / 9,000 feet in hilly terrain and extreme cold areas. Stop. Learned counsel for the petitioner submits that the place where he is presently being sought to be transferred by the modified order is also a hard station, as is reflected in
my lord, the annual transfer guideline, my lord. Page.
No, where is that list?
List, my lord, that is.
This is a part of the guideline.
Lordship.
Okay.
Page 123, my lord, serial number 30.
123.
Their affidavit.
Serial number
30, my lord.
30. It is submitted that the said place of posting, namely Bagaha in the state of Bihar, where the 21 battalion of SSB is presently posted, is shown to be a hard station. Stop. Learned counsel for the petitioner also refers to the transfer policy followed by the SSB by the standard operating procedure notified on 4th of March 2024. Stop. Referring to the clause, referring to the annual transfers specified therein, it is submitted that all annual transfers, in respect of all annual transfers, five choices of posting will be given by the personnel through small e hyphen DAS. Stop. According to the petitioner, he has given five choices of transfer, considering his medical condition.
Lordship, that is prior to his transfer to Bagaha. After Bagaha, he given 3 choice of posting. And out of that, Lordship, he had given 1 choice of posting, 68 Battalion, Devendra Nagar. And as per the list, Lordship, Devendra Nagar is also a hard area, which shows that he don't want to leave state of Assam.
submitted 5 choices of posting, and when his earlier choice of posting was issued, when his initial transfer order was issued, and thereafter he again submitted 3 choices of posting when the earlier order of transfer was modified, and he was shown to be sought to be transferred to Bagaha in Bihar. So the learned counsel to the petitioner submits that he has one daughter, student of class 10, and also has medical ailments, and including mental health issues, and therefore at present he is transferred out of the state of Assam to the present place of posting is not acceptable, being violative of the transfer policy, as well as the medical condition suffered by the petitioner, as well as his daughter. So the impugn transfer order should therefore be interfered with, set aside, and the petitioner be permitted to stay in his present place of posting. Stop. Better. The submissions of the counsel for the petitioner is strongly disputed by the learned CGC MSB Sharma. So it is submitted that there is no violation of the transfer policy notified by standard operating procedure dated so and so. So the learned counsel, referring to the affidavit filed on behalf of the respondents, submits that the petitioner had been posted in the state of Assam since 3/2/2020.
So 3/18. In present place of posting 20. In Romia, he was there from
29/3/2018.
That was on a normal
It's
posting.
submitted that since 2018, the petitioner has been posted in Assam, and which is contrary to the transfer policy. Stop. It is submitted that in terms of the transfer policy, ordinary tenure in a place of posting is 3 years. And the petitioner has crossed that period long back, and therefore is required to be transferred out. And there is no infirmity in the same posting. Stop. It is further submitted that the review medical board opines employability restrictions only in hilly terrains and at postings above 2,700 meters and above. So the posting to which the petitioner has now been transferred to, namely Bagaha in the state of Bihar, is not a hilly terrain, and the petitioner will be permitted to avail of all medical benefits and physiotherapy care as required. Stop. It is further submitted that the contention of the counsel for the petitioner that Bagaha is a hard station and therefore will cause hardship to the petitioner considering his medical condition is also belied by the fact that the petitioner, in respect of the subsequent modified transfer, had given 3 choices of postings, which included Devendra Nagar.
Yes, 68 Battalion, Devendra Nagar.
68 Battalion, Devendra Nagar, in the district of Sonitpur.
Yes,
Which
is also a hard area.
reflected as a hard area. So therefore, the only grievance the petitioner has is that he does not want to be transferred out of the state of Assam, and which is contrary to the transfer policy. So in support of our contentions, the learned counsel has referred to and relied on a judgment rendered by the apex court in S.K. Naushad Rahman and others reported in 2022 12 SCC page 1, referring to the said judgment. The
Paragraph 24, 25,
paragraph 24, 25, 26,
28 and 29.
28 and 29, the learned counsel refers to the judgment of the apex court, laying down the guidelines in which are to be adhered to in respect of transfer policies in all India service and in respect of services which require all India posting. So the petitioner being an employee under the SSB, it is an all India service and the petitioner is required to be transferred in response to the call of duty and as per administrative exigencies across the state, across the country. So, parallel counsels for the parties have been heard. Pleadings on record have been carefully perused. So, it is not in dispute that the petitioner has suffered from fracture of the backbone. Stop. The review medical board opinion dated 23/1/2025, which is placed before the court by the petitioner, reflects the following under the heading specific restrictions regarding employment within courts, serial number 10, court query. Stop. The medical report also reflects that the petitioner's medical condition has been brought down. The petitioner's medical condition has been brought down to category S1, H1, A1, P2 within bracket T minus 24 plus 24 bracket close E1. Stop. Para. The medical report clearly reveals that there are restrictions in respect of employability of the petitioner in places having altitude of more than 2,700 meters / 9,000 feet in a hilly terrain or in extreme cold areas. Stop. Medical advice is to avoid forward bending, weightlifting, running, jumping, crawling, hill climbing, and handling of weapons. Stop. The further opinion is to continue treatment and with regular follow-ups. Stop. The next date of review medical board is reflected as 11/7/2025. Stop. However, it is informed to the court that the review medical board was not held and the further date is not known to the counsel for the petitioner as on date. Stop. The transfer guidelines enclosed available in the pleadings have also been carefully reflected, carefully perused. Stop. The transfer guidelines are published, are notified as standard operating procedure by the memo number so-and-so dated 4th of March 2024. These transfer guidelines presently provide the parameters on which the transfers, including annual transfers, are to be issued. Stop. The clause 5 of the guideline reflects that the tenure of postings are ordinarily for 3 years, except for those in the high altitude where the tenure will be 2 years. And on completion of the tenure in a unit of a particular frontier, the personnel will be transferred to another frontier. In respect of annual transfers, the personnel are given are provided with an opportunity to furnish 5 choices regarding the places of posting. Stop. This choice has been availed of by the petitioner. In the first impugned order of transfer, the petitioner had reflected 5 choices, and pursuant to his representation reflecting a representation on the ground of medical condition, his earlier transfer order was modified to the present place where the petitioner is sought to be transferred, namely Bagaha, the state of Bihar. Stop. Even along with the said application, the petitioner had given choices of posting, 3 choices of posting, including one at
68 Battalion, Devendra Nagar.
68 Battalion, Devendra Nagar, in the district of Sonitpur, state of Assam. Stop. This fact is submitted by the respondents and which is not disputed by the petitioner. Stop. The further contention of the petitioner is that considering his medical conditions, he ought to be posted, he ought not to have been posted out of the state of Assam, and more particularly to Bagaha in the state of Bihar, as this is a hard posting. Stop. However, in the choices which the petitioner had already offered, along with his representation seeking modification of the earlier order of transfer, he had given the option of being posted at 67 battalion. And Devendra Nagar?
68.
68 battalion at Devendra Nagar in the district of Sonitpur, in the state of Assam. Stop. This place of posting is also reflected in the enclosures to the transfer policy and shown to be a hard posting, age within quotes. So. Parent. It is no longer a syndigra. That transfer is an incident of service, and the employer is best suited to decide the places of posting of the employee depending on administrative exigencies and the need or the requirement of service to be rendered by the employee. So, reference in this case may be made to the judgments, several judgments of the apex court rendered in so and so situations. So, ordinarily, unless the person issuing the authority issuing the transfer is not competent in law, or there is a mala fide intention in issuing the transfer order, or the same is contrary to notifying policies, rules, regulations, etc. If writ court is normally not required to interfere with the transfer orders. Stop. In S.K. Naushad Rahman, the apex court had clearly laid down the guidelines with respect of transfer and posting of personnel who are under the All India Services. Stop. Although the present petitioner is not an employee under the All India Service, but is an employee, is employed under the SSB. The same is a discipline force and is required to undertake its responsibility of law and order as well as providing its, as well as maintaining the frontiers of the country. And therefore, it requires transfer and posting across the country in various stations as per the need and requirement and the call of duty. So, However, the guidelines of the apex courts in this case will also be applicable in the facts and circumstances of this case. And the same are extracted below, para 24 onwards. 24, 5, 6, 7. Mm. Twenty-eight, 29. 29 all again. So. The review medical board report is placed before the court is also carefully perused and duly taken note of. Stop. There is no averment made in the writ petition or any submissions made before the court, the place where the petitioner is sought to be posted, namely Pagaha in the state of Bihar under 67 Battalion. The facilities of medical care and treatment are not available. Stop. It is not disputed at the bar that the said place of posting is not a hilly terrain or is subjected to extreme cold areas or is above 2,700 meters / 9,000 feet or at high altitude. Stop. Under such circumstances, this court is of the view that the claim made by the challenge made by the petitioner cannot be, in respect of the transfer orders, cannot be sustained. The same is therefore rejected. The petitioner will report to his place of posting as per the order dated so and so, modified subsequently. So, however, considering the fact that the review medical board was scheduled on 11/7/2025 as reflected in the opinion of the review medical board, and which the petitioner claims the petitioner was not which the petitioner claims was not constituted, or the petitioner was not examined by the state review medical board. We direct the respondents to constitute a review medical board forthwith and examine the petitioner regarding his fitness for duties, regarding his employability, and the review medical board will thoroughly examine the petitioner, and thereafter, if the petitioner is found to be otherwise fit for services as is indicated in the review medical board issued earlier, opinion of the review medical board issued earlier, dated 25/3/2025, the petitioner will proceed for joining in his place of duties as per the order dated. Review medical board be constituted within
Weeks.
2 weeks. Within 2 weeks. And the petitioner be examined thereafter by competent medical professionals, and the opinion of the same review medical board shall be served on the petitioner. This entire exercise be completed. How much time will you require to examining?
Within 1 month.
The entire exercise be completed within a period of 4 weeks. From the 4 weeks from today. The impugned transfer order shall not be given effect to, insofar as the writ petitioner is concerned, till 15th of September. The writ petition disposed.
Item 9.
May it please the Lord. My lord, in this petition, we have assailed the transfer order, my lord. There are 2 other proceedings, my lord. I'll respectfully pray, my lord, all these cases should be tagged together and maybe take it up in the next week. My lord, initially what had happened, the petitioner, my lord, he was an assistant professor in oncology. Now he was seeking promotion to, my lord, associate professor. Now he was denied. Then we approached this honorable court, single judge allowed us. Then, my lord, we were not given the
It was the
retrospective.
matter where we had granted some interim order in a connected matter.
Yes, no, what I'm saying is, my lord, all these matters are interlinked. So what I pray for is, my lord, this matter may come up along with WPC number 4108 of 25, my lord, and contempt case number 170 of 25. It can be taken up next week, my lord.
One thing, my lord, I'd like to point out.
Contempt case?
Contempt case number 170 of 25.
Yes.
This is a transfer issue, my lord.
Next second. Otherwise, these matters are fixed on 27/8/25, my lord.
It come on.
So it can come on 27, yes.
And transfer, my lord, order was issued. It was stayed by the honorable court from February, my lord, till August now, my lord. He is enjoying an interim. So lordship will decide this. Other than
No, my
fresh
lord.
cause of action, which my lord, this is to, they have challenged it, my lord, they said in the under
Decided
petition.
together. Why? What is the, it is coming up on 27.
27/8.
Let it come on 27.
Yes, on that
All
day,
the
lordship will
matters.
take a call, yes.
We'll order that an attempt will be made to dispose of.
Yes, yes.
All of them. 27 or 28.
And my lord, your
20 or
lordship,
27.
I think last week your lordship passed an order that I should be paid my salary. They have not paid as yet.
Well, that, my lord, is under process. I've got a specific instruction, my lord, yesterday also. It's under process, it will be paid. Current salary or not. Earlier, it will take some time. But the fact is, my lord, the particular department where the petitioner was working, or as on that, because of the interim, he's still in Guwahati. That department has itself has been abolished. That abolition order is under challenge in another petition.
What happens to that?
Not only
Oncology?
Oncology, my lord, now, my lord, so far as the National Medical Commission, now it's instead of, my lord, MCI is the National Medical Commission. They've issued a regulation recently. As per their regulation, my lord, there is no Department of Oncology. So we have already created a new one, my lord. All other employees like that of the writ petitioners have been transferred to various colleges. There are nobody is there, my lord, as on that of that particular.
Mr. K.N. Chaudhary, learned
Yes.
senior counsel, assisted by Mr. Parity.
Only thing that endeavor part may be
Mr.
there, my lord. I'll try to find the
Boyle
affidavit
learned additional
yesterday.
in
Next
for the
week. itself.
respondents. It is submitted by Mr. Chaudhary that two matters filed by the petitioner which are interconnected are listed on 27th of August. He submits that this matter also be posted on 27th as all the matters can be taken up together. Mr. Gogoi submits that the present matter pertains to a transfer petition which is challenged, and by virtue of the interim order, the petitioner is still posted in his present place of posting. Therefore, there is an urgency in disposal of this matter. He therefore submits that on the next date fixed, which is 27th, there should be an attempt to dispose of all the writ petitions. Prayer made by both councils allowed raised this matter on 27 August along with WPC 4108.
Yes.
Of 25 and
4108 of 25 and contempt case number 170 of 25.
contempt case 170 of 25. Stop. An attempt will be made to dispose of all the matters on that day.
It will.
Yes.
Interim order will be extended.
Interim order passed earlier will continue till the next date of listing.
Deep breath.
Item 10.
In this case, I have received instruction, the inquiry is completed, but report is yet to be submitted to the university. That matter may be finally heard on 4th of September, Lord's Sir. On 4th of September.
Considering that the inquiry is already complete, Your Lordship, perhaps we could, because the matter relates to suspension of the petitioner, and that is what was under challenge. Now, if my learned friend is submitting that the inquiry is complete, then perhaps we could wait for the inquiry report. And if the result is in my favor, hopefully the suspension will be revoked, Your Lordship. So, September 1st week, Your Lordship. 4th of September.
You've been given some fillers that it could be in your favor.
No, your lordships, that's my learned friend has given me some pillars.
I am also not aware.
I am not aware of it, your lordships.
Inquiry was.
But considering the fact that I have produced a lot of evidence in my support, I'm 100% sure that the inquiry would go in my favor. Because it was a completely false complaint against me. Your Lordship.
Heard MS RS Siroti, RS Chaudhary, Learned Counsel, and Mr. Kial, SC Kial, Learned Counsel appearing for Assam University, and Dr. Who's appearing for Agarwal?
MSS.
MS so-and-so appearing for UGC. So Mr. KL submits that the inquiry proceedings against the writ petitioner has been completed and the inquiry report submitted.
No, but we are waiting for
And the inquiry inquiring authority is in the process of furnishing the inquiry report before the disciplinary authority. And thereafter the disciplinary authority is likely to take appropriate decision and pass orders in the matter.
Yes.
He therefore submits that the matter be posted after 2 weeks. Stop. Counsel for the petitioner does not object to the prayer made. Accordingly, let the matter be listed as agreed to. Let the matter be listed on 4th.
Lordship, 2nd of September.
2nd of September.
Much of.
Deeply obliged.
Item 11.
Mediation?
Yes, Lordship, mediation, we need one week time to confirm whether we'll go on mediation or not.
What is the subject matter?
Subject matter. What is this? Let's hear and discuss some.
The bank is agreed that to send for mediation.
You go for mediation.
Yes.
We are sending you to mediation.
Yes.
Mediation. 5th of September. You'll have to appear on 5th of September.
Not sure.
Item 12.
The petitioner is ready for the.
Mediation, all right, mediation. 5th of September.
13.
There is a specific observation on direction, Lordship, on the earlier occasion, Lordship.
Yes, anything?
My lord, if they want to try for mediation, my lord, let it go there. Let them sort it out.
Mediation.
If.
14.
May I please, my lord? In this matter, the other side was supposed to obtain instruction, my lord.
Family pension. You are not entitled to family pension. You are the son.
I am the son.
You are 56 years old. You are not entitled. But
My
other,
lord,
other retirement benefits you may be, if there is any.
yes, ma'am. But employee's wife was alive till 2017.
This will require a decision in the matter.
Yes.
Who's for the respondent here? BTC? BTC council? Who's for BTC? Yes, BTC. Scroll, call up after something. Wait for something.
15,
Yes,
For mediation.
mediation. All right. Councils submit that the matter be referred to mediation. List on 5th. 5-9.
16,
matter may not settle by the mediation center. The law court involved in the case, my lord. The petitioner serving 17 years qualifying service, my lord. And ordinate bench passed, my lord, observed that, my lord.
Readings are complete.
Complete, respondent also filed affidavit, my lord.
All right. You submitted that questions of law are involved in this matter, as the claim is made for pension by the petitioner who was serving as a master role worker under the executive office of the executive engineer irrigation Jorat division. Stop. It is submitted that these matters is covered by orders passed by coordinate benches in Samjita Roy and others versus so and so.
No, my lord. Subsequent order, page 59, my lord. Coordinate bench of this honorable court, my lord.
59.
59. Wherein, my lord, this honorable court, my lord, observed that only 10 years qualifying service is required.
Covered by judge order dated income Lenteng WPC 2538. Very regularized.
Regularized, my lord.
Then after regularization, how many?
My lord, 17 years service, my lord. Total.
After regularization?
No, my lord. My lord, from the date of initial appointment.
So 6 years was deducted.
No, my lord, total 17 years, my lord. But coordinate.
But even if 6 years is deducted, you are entitled.
My lord, but in some cases, the government stand is that, my lord, 20 years is required. In case of master worker, my lord. But coordinate batch observed that, my
Your
lord.
total service
17 years.
prior to regularization?
Prior to, my lord, regulation, my lord. And
17 years.
total, my lord, 17 years.
17 years.
Total.
Then?
But respondent stand is that, my lord, 20 years is required, my lord, total. And coordinate bench of this honorable court.
But it is this coordinate bench order has been appealed by division bench also.
Is the another, my lord, another issue, my lord, regarding, my lord, Sanjita Roy, my lord.
Huh?
Regarding deduction.
Deduction part,
my lord.
yes.
That is, my lord, another issue, my lord.
Yeah.
But subsequent coordinate bench or order observed that, my lord, only 10 years required.
Is it 10 years or 20 years?
That is the issue, my lord.
20 years.
Huh?
It is 20 years.
Counter. But
20 years? Where?
In our affidavit, lots of 20 years, lots.
In your affidavit?
Filed by respondent number 2 lots. 11 para is para 5 lots.
the matter for admission, my lord. Is that, my lord, respondent denied, my lord?
Counsel for the parties do not agree that the matter, counsel for the petitioner does not agree that the matter be referred to mediation. He submits that since the pleadings are complete, matter be listed for admission. List again on 29th. August.
Obliged.
Lord, I appear on behalf of Mr. B.
Mr.
Sharma.
D. Bhattacharya for
On behalf of B. Sharma.
on behalf of B. Sharma for accounting general, the H. Chakraborty for
On number 2, Lordship.
respondent.
Obliged.
Obliged.
29.
Item 17,
None appears passed over. None appears for the petitioner, Mr. P. Sutia for the respondent.
18,
My lord, this matter has become infructuous, my lord. They have received the money.
Counsel submit that the claim of the writ petitioner has been redressed. She has received the amounts claimed from the Assam Plains Tribes Development Corporation Limited. And therefore the matter has become infructuous. Accordingly, writ petition stands dismissed as infructuous. The interim
Right.
orders, if any, stand vacated.
Nine.
Pending ayes are also dismissed.
Nine.
What is the item number? 18.
19 or same, my lord.
And 19 also
19.
same.
Similar, my lord.
All right. Yes.
item 20. May I please, Herein, my lord, I'm claiming by this way of repetition, the pensionary benefits. Sorry, my lord. My lord, family pension with the repetition. My lord,
who are you?
My lord, I am my lord, wife of the deceased husband. Due to conviction in a criminal case, my lord, he was dismissed from service. Subsequently, his dismissal order was set aside by this honorable court. Against the said order, my lord, they have preferred a criminal petition before the honorable Supreme Court. And the honorable Supreme Court, my lord, set aside the reinstatement order. And against the order of dismissal, my lord, I have preferred a writ petition before this honorable court. And the operative portion is there at page 49.
Now, where is the order of the apex court?
The apex court order is there, my lord, at page 32, lord. Operative is 37, my lord.
Page number?
37, lord. Then, my lord, lordship may kindly come to page 42, my lord. I have preferred a writ petition against the order of dismissal. My lord,
So
43.
now the question is, do you want the matter to be referred to mediation?
Yes,
Third council court, please. Matter will be referred to mediation, 5th of September.
Supplementary list for admission, page 27.
Yes.
Malad, here, Malad, I have a prayer. Malad. I pray for 1 week time in the matter. Malad, against the order of 2910, Malad, we have preferred an appeal. Malad, I may be given 1 week time to pursue that. Malad, I'll apprise the honorable court. Malad, 1 week time is required.
Yes, Mr. Lowry.
Lord, it's okay, but every time a different council appear and make submissions. This is the fourth occasion, Miller. That's the difficulty. And by their own saying, Miller, that seal cover is not applicable in case of nomination to IS, then you can do it provisionally. That who is preventing you from doing that? At least they should go ahead with that subject to the outcome of the case. But, it is their stand in their affidavit that the concept of seal cover is not applicable, but under the regulation 5, they can make provisional. Then let them do it, not subject to the outcome of the case. My only anxiety is that otherwise I'm working.
But if I'm allowed to permit, my lord, there is a development, my lord, it has come to my knowledge, my lord, that against the acquittal order, where he was acquitted from the criminal charge, the state has preferred the leave petition, and in the month of July 2024, notice was issued in that. It was not in our knowledge, my lord. It has come to my notice, my lord. And so at this stage, lordship may not observe anything, my lord.
No, my lord, let the criminal appeal also be allowed, let the writ appeal, but the idea of doing is to, my lord, balance the equities. If, my lord, they have filed their own affidavit where they have taken this stand that seal cover is not applicable, but then provisional selection. I'm only saying, my lord, let provisional selection be made subject to the outcome of this writ petition or writ appeal, whatever it is. Then, my lord, in that case, nobody suffers any prejudice.
No, it will, in my respectful submission, it will complicate the situation.
What is the question of complicating? Don't give effect to that, but do it.
Provisional selection, you make it, don't give effect.
Yes.
Leave of the court.
Lordship may give us 1 week time. Let the matter be taken on 26th or 27th. The next week I pray for.
Well, the problem is the litigant can't go on because every time a different government advocate will appear and make this is not acceptable, Mila.
We are appealing.
Mr. K. N. Chaudhary is listed by Mr. D. Nath, the additional senior government advocate, appears for the respondent. He submits that an appeal has been preferred against the judgment and order rendered in WPC number
1053 of 2024.
1053 of 2024, which was filed with the petitioner.
Petition was filed by them.
Which petition was filed with the petitioner. He submits that this will have a bearing in the proceedings of the present. In the present proceedings, he therefore prays for a week's time to apprise the court about the status of the appeal filed by the state against the judgment and order. It's on 26th.
Yes.
On let it be 27th. 26th is a
27th.
Is a holiday. Lordship.
26th is not a holiday.
25th is a holiday. It's a
all right. 27th.
25th holiday night. What's the okay.
Lordship, I have a prayer.
We'll come back at 2.
Lordship, indulgence to make a mention in respect of item number 58. Day before yesterday, the authority has dismissed my appeal, my lord, after 7 years, my lord. So kindly give me 2 weeks time for further taking action on the petition, my lord.
58,
my lord.
Item 58 to be listed after 2 weeks. On a request made by Mr. D. N. Bhattacharya.
How late?
Time being item 14.
Lordship, have a look at the order, my lord, on passed on 14/5/25.
Yes.
Lordship, on the
can it be referred to mediation?
Because the service, they want to reconstruct the service movement.
Lordship, the administrative control of Mahkuma Parishad, Lordship, is not under the control of the BTC authority. And we have written to the Commissioner and Director of PNRD of the state.
Who's for PNRD? Yes,
For reconstruction of the service book, we have already accorded sanction. The Secretary, Kokrajhar Mahakuma Parishad. On 4/6/2025.
who represents the secretary?
Lordship, it was BTC, as per my instruction on 25th February, Lordship. This has come subsequently, that up-to-date information I do not have, Lordship.
You are representing the secretary?
Yes,
You
BTC.
get instruction now that the sanction has already been granted?
Yes, that I will.
Yes. Heard Mr. N.J. Dotto, counsel for the petitioner, Mr. B. Chaudhary for BTC, Mr.
AK Ghosh.
DK.
AK.
AK Ghosh for the PNRD department. Mr. Ghosh submits on instructions that the by communication dated 4/6/2025 issued by the Joint Commissioner of the PNRD department. Approval to reconstruct the service book of the husband of the petitioner.
Father.
Father of the petitioner has been accorded to the in-charge secretary, Kokrajhar Mahakuma Parishad. So, there are Mr. Copy of the said communication has been placed before the court by the Standing Council PNRD, and the same is kept on record. Para Mr. B. Chaudhary, London Standing Council BTC, means that he'd like to obtain his updated instructions in view of the sanction being having been accorded. He prays for
2 weeks, Lordship. I will try to get it through the BTC authority because Mahkuma Parishad, Lordship, I cannot represent.
who represents.
Lordship, I don't notice has already gone or it has to go, Lordship. I will try to get it through the
Chief Executive Officer. Who is the Chief Executive? The officer of the BTC has to be somebody from the government.
But Lordship, I will try to get it.
Additional DC hertz. Chief Executive Officer slash someone. It will be ADC.
ADC has to be there. Let this matter therefore be listed after 2 weeks. 28th,
Well,
29th,
well,
29th.
Items 1 and 2.
This matter, we thought we'll declare in court, but we are not even halfway through the list. So we'll reserve it. We'll try to deliver it within this end of the month. The judgment. All right?
So I think
records will be necessary.
Yes.
We'll have to look into the records.
Yes, that is there.
You
Can we hand it over, madam?
yes to the court martial. Third counsel for parties reserved. The which department is this? Excise.
Excise department, Lordship.
The counsel for the excise department has also handed over the relevant records to the court master, who is directed to keep it in safe custody. We'll try to deliver it.
Yes, because
by-
in the next month itself, Lordship is.
Therefore, we'll try to deliver it by the end of the month.
The-
Yes, reserve.
For hearing items 21 to 47.
Please perform my report to Malka Rajendra. Some type that word. Yes. Complete, pleadings are complete?
Yes, Rasif. Ratings are complete.
Then? Yes, yes.
It's an item 23. I have to seek some time, minus, please. Just allotted to some
Right,
time.
other matters?
We are ready, madam.
Lordship, in some matters where Mr. D. Dega is there, Lordship, in item number 23, 24, 25,
23 to यहाँ कोई भी
23,
नहीं। अभी तक तो मेरे
24, 25, 29.
So these are all connected matters.
Connected matters. These
You are
three
seeking
matters
an
he
adjournment,
instructed.
then we'll have to adjourn the whole matter.
No, Lordship. Other matters, Lordship may very well take up, Lordship. Other matters, Lordship may take up. Because in these three matters, he instructed me to take an adjournment.
Who is appearing in item 21? What is 21?
In item 21, your lordship, there are two petitions. In respect of the petition number 1, he failed to secure the cut-off mark, your lordship. So,
He's
in
out.
in respect of petition number 1 only, I don't want to press his case, your lordship.
Yes, then petitioner 2?
Petition number 2, your lordship.
What is your, what was the grievance?
My grievance is that, your lordship, his candidature was rejected at review medical board, your lordship, on the ground. Yes, 43, your lordship, can have you. And the ground of rejection has been cited herein is that tinea versicolor base region and upper and lower base, extensive involvement. It was the ground. But in page 44, your lordship, this is the opinion of the medical expert, your lordship. In bottom, it has given the present condition is a treatable condition, does not cause any risk for the patient, is not a contradiction for the job. It is the opinion given by the medical expert, your lordship.
Where is the medical opinion of the?
Medical opinion, that is.
Of which force is this? This is held combined or separately force wise?
Combined.
all are combined, Lordship.
No, the medical tests are held by a combined board,
Different board, Lordship.
different board. So where is the report?
Some medical.
Where is the report of the medical board?
In item number 21, learned CGC SS Roy will leading, and he is another next on another court.
At
Lordship.
least let us go through the pleading and understand what is it. It has been
Yes.
shown to be part heard, or we release it from part heard if you are not interested to hear. Continue with the hearing.
The medical report is not, I have not annexed that report, your lordship, but the rejection slip, your lordship, I have annexed. That is page 43.
Not even in the affidavit.
In affidavit also not there.
So why should we accept the civil medical report, overlooking the medical report of the services?
In the affidavit, your lordship, you will find annexed R11, your lordship.
Page number?
$179, and thereafter medical report is there.
So this is
175 onwards.
175.
Yes.
What is there?
176 is the laboratory, Department of Laboratory Medicine.
You are not prepared to argue the matter today? Are you not ready to argue the matter?
No, I'm ready, Your Lordship.
Then? Where is the finding?
Finding is page 79, Your Lordship. But in the
79.
179.
179 is the finding of the Guwahati Medical College. That is at your instance. Or where you referred.
Perhaps the
You are not aware. Is anybody interested to proceed with the hearing or we defer the matter?
Item 26 maybe.
Huh?
I have in 26 minutes.
26.
then 21, Your Lordship, then it may be some other decision.
So we are adjourning the matter, we are releasing it from parted. There's no point keeping it in parted.
My lord, may take up one by one, my lord, if
No,
possible.
one by one, all these matters are taken up together. For what
My
purpose?
lord, all are independent, the issues are independent, my lord, here.
But I don't know who's clubbed it.
Though the reason is that they have rejected on the ground of medical unfit, my lord. That's why it was tagged. But the unfitness are different in all the cases.
Which number? What is your?
26 minutes.
26.
Impugn rejection kindly, my lord, see, my lord, page 49, my lord.
Here notice has not been issued. There is no order here. Item 26. Affidavit filed.
Yes, my lord.
Yes. Right. Yes, tell us.
Page 49, my lord, shall you see? In interest of the petitioner has been rejected on the ground of, my lord, systolic hypertension, my lord. This is the ground, my lord, by the review medical board. My case is there, the ground of rejection has violated the, my lord, guidelines for review medical examination, my lord. The, my lord, guidelines, my lord, kindly see, my lord, is 100, my lord. And operative portion page 101. 101, my lord. Guidelines for review medical boards, serial number 2, my lord. For the defect for which candidates has been declared unfit should be examined thoroughly and the findings must be got supported by proper investigation reports if applicable, my lord. Now kindly see below, my lord, 3E, my lord.
Page 100.
Page 101, my lord. Page 100, guidelines for review medical boards, serial number 2, my lord, close to. For the defect for which candidates has been declared unfit should be examined thoroughly and the findings must be got supported by proper investigation reports if applicable. Now kindly see, my lord, 3E, my lord. For candidates who have been rejected on the ground of hypertension, petitioner was rejected on hypertension, my lord, and tachycardia should be admitted hospitalized by the board before giving their final opinion regarding the candidate's fitness or otherwise. The hospitalization report should indicate whether the rise in blood pressure is of transient nature due to excitement, etc., or whether it is due to any organic disease. In all such cases, X-ray and electrocardiographic examination of heart and blood examination like cholesterol, lipid profile, creatinine, etc. tests should be also be carried out. My case is there, my lord. No report, no such report is, my lord, done by the authority, my lord. Only, my lord, reading of, my lord, blood pressure, they have rejected my case. So my kidney test has been rejected in gross violation of the guidelines method. And I have also checked up from my lord, civil doctor, my lord, that report kindly see page 51, my lord.
But come to page number 112. Affidavit.
Yes. Yes, yes, my lord. There is only reading of my lord blood pressure, my lord. There is no correlation with the my lord blood test report, echocardiography report. That is not done, my lord. It is only reading of blood pressure, my lord.
Only that is required, Lordship.
That was required.
Guidelines say it is required.
Required, Lordship. It was done, Lordship. This is the records, Lordship. Medical records.
Why have we not referred it
Lordship,
to the affidavit?
This is the original records, Lordship.
No, but some reference should be there that it is there in the medical report. Yes, let us see.
In the rejection also that does not refer, my lord.
Rejection may not refer.
If other report is normal, my lord, there is no.
These are available.
But
Echocardiogram.
whether that is, my lord, say that is normal or my lord, something is there, my lord, in the reports, my lord.
But BP,
Investigation reports, my lord.
BP is factual, Lordship. It defines.
BP is fluctuating.
You done ECG in the GMC?
No, I have done, my lord, at my lord, Bongaigaon Civil Hospital, my lord.
Wherever, ECG.
I have an next, my lord, case 53, my lord, blood test, my lord.
Blood test will not reveal hypertension. Sorry. Where is it?
Case 53, my lord.
53.
53.
Ah.
This was done at Bongaigaon Hospital, my lord. Bongaigaon Civil Hospital. Cholesterol, glucose, creatinine.
No, your ground for rejection is hypertension.
Hypertension.
So from what document you want to show that civil hospital has said there is no hypertension?
Case 51, kindly similar.
51 is type copy of?
Is 52.
52.
Yes. Here, my lord, my BP is found, my lord. 136/80, my lord.
on the very next day, my lord, on 23 10.
Were you admitted in the hospital?
No, Lord.
No, my lord.
Lord.
Then
I
you
go
have
to
to
the
be
hospital.
admitted. The guidelines say that you have to be admitted in the.
By the department, my lord.
The
Yes.
composite hospital you are admitted.
Admitted, my lord.
Here you just go as an OPD patient and you get your blood check,
Yes, my lord.
blood pressure check.
Yes,
You
ma'am.
may vary, you may not vary.
That is not only, my lord.
Yeah.
Guideline says, my lord, the blood pressure, high, excess of blood pressure due to excitement may be, my lord. That
Could
is
be.
why, my lord, correlation
No.
of
See,
BP.
you are relying on a report of a civil hospital.
Yes, my lord.
To say that the findings of the composite hospital is incorrect.
No, also, I am saying, my lord,
Ah.
the finding of the composite hospital, my lord, not correlated with the, my lord, finding, my lord, of test, my lord, medical test.
All right.
That is also my case, my lord. So, the guideline says the finding of BP, my lord, should be correlated with the, my lord, medical test, my lord.
Where is the guideline again?
Yes, my lord. Page 101, my lord.
101.
Page 101, my lord, at least.
Hmm.
First, serial number 2, my lord, close 2. For the defect for which candidate has been declared unfit should be examined thoroughly and the findings must be got supported by proper investigation reports, if applicable. Now, clause 3E. For candidates who have been rejected on the ground of hypertension, tachycardia should be admitted, hospitalized by the board before giving their final opinion.
What is the respondents? What is the meaning of, what meaning do you ascribe to this guideline 101? Clinical findings should be corroborated. From the report,
Yes.
it is not very clear.
44. 44 Omitted.
Lordship,
This-
which
this-
guideline he is relying, Lordship,
was
it has been omitted
omitted.
by 21 guidelines.
Where
Yeah,
is that 21 guideline?
Yes, that is also there.
He's not saying that, Lordship.
In the affidavit, my lord, that is same, my lord, condition.
Well,
Is
Condition
it a
is same.
part of the affidavit?
Yes, my
Yes,
lord.
Lord.
Page 130, my lord.
This is
Page 1130, my lord. Clause E, my lord. Same, my lord. Same.
no, not same.
rejected should be admitted and should be witness of it.
And he was admitted, Lordship. 46.
Yes.
It was done, Lordship.
Hmm?
Clause E, page 130 of our affidavit. For candidates who have been rejected on the ground of hypertension, thyroxidia, should be admitted, hospitalized by the board before giving their final opinion regarding the candidate's fitness or otherwise. The hospitalization report should indicate whether the rise in blood pressure is of transient nature due to excitement, etc., or whether it is due to any organic disease. In all such cases, X-ray and electrocardiographic examination of heart and blood examination like cholesterol, lipid profile, creatinine, etc. tests should also be carried out.
Yes,
And
ma'am.
all are done.
All are normal, my
He
lord.
was admitted and his BP was fluctuated. He was admitted for 4 days, Lordship. And every day his BP was high.
Yes, my kindly see 2D, my lord. 6D, my lord. Page 130, top in them. Yes,
Review medical board may obtain opinion of concerned specialist or specialist of government medical college and hospital in case of in doubt. Therefore, in cases of rejection,
Any case of doubt, Lordship.
yes, madam. Therefore, in
No, see,
cases
here, I'm not, here what has happened is you have the reports, but in terms of the guidelines, it says it must be corroborated.
Yes.
There's a clinical finding that yes, he is suffering from hypertension, etc. But although the reports are there, there is no indication that this finding is corroborated. It may be understood by a medical professional. But for non-medical professional, we'll require a corroboration.
All of them are seeking for a review medical board. Our stand is that their review medical board has been done, and after that, no further review board can be held.
No, that review medical board you have done, but in terms of your own guidelines.
Yes, Lord.
There has to be corroboration. In other words, even if we go by the subsequent modified guidelines, it's very exhaustive. That these reports must indicate whether it is due to any organic disease or something. Supposing the blood pressure rises, if it is not because of excitement, then it must be because of some other reason. Where is that finding? At least that preliminary suggestion that this is not relating to momentary or transitional, transient situations. It is because of some other disease, and therefore this person is not fit. You are rejecting somebody's claim for employment. That person must feel that he is not fit to be in the service, which must be properly explained. You can't just, I'm not saying that these reports are not, these reports are perfunctory. I'm not saying that. But mere perusal, it is difficult to understand as to how this has been correlated.
That instruction, Lordship, we have to take on that reports, Lordship, because the medical officer who finded them, Lordship, they are the best person to say that, because
all medical, you see, there is a difference between lawyers and doctors.
Lordship.
As lawyers, you earn by the number of pages.
Lordship.
The doctors, as many number of pages or one page, the salary remains the same. So therefore, they like to be very crisp, and because normally these medical reports are to be seen by a medical professional. Perhaps any medical professional going through the records may come back with the same findings. But now that we are called upon to examine, it is not possible unless you correlate.
Understand.
Who will correlate now? It is only the doctor who has given this finding has to correlate and supported by an affidavit. If that doctor is not there, then they are entitled to a review medical board again.
As per guideline, on the ground of hypertension, he was rejected. And here on revised guideline, paragraph 7 point E, this is only for example. Paragraph point 7.
That's what I'm saying. That
Yeah.
example, the example is given
Yes,
to understand as to how the evaluation is to be undertaken.
Yes.
So in case of a blood pressure, it has to be, number one, the person has to be hospitalized. Then his blood pressure hospitalization report must indicate the cause of rise in the blood pressure. Does your report indicate that? Doesn't indicate. It merely says it is, which it is on the higher side, which is why he is controverting it by a report of a civil hospital.
Yes.
If your reports were clinical findings are corroborated by the reports, then it would be evident.
Let me have the instruction on that, Lordship, whether we can file an affidavit to that effect. It's
How will you explain it in affidavit? It has to
That-
be by way of a.
by a doctor, the
Finding.
board officer, Lordship. Because by the board officer with a file. By correlating the, because all the
Instead
reports.
of that, why don't you put them through another round of review medical board?
Because this correlate
These
Lordship.
findings. And give us an exhaust, give us give the court a complete report of their medical status.
Let me have this instruction whether we can, or otherwise we can file an affidavit by the board member who has given this by correlate, because all the records we have.
See, there is a ECG report here. This ECG report, any doctor with their training will be able to identify whether this is good or bad or alarming. But this ECG report is not connected with the opinion given by the board doctor. What is systolic hypertension?
It's not defined.
Can you show these reports to him?
Lordship, because his report.
Please show this page number 42. If you see the left margin.
Yes.
You will find your BP notings.
Yes. That is my case, my lord.
Ah.
They have only noted my BP, my lord, and rejected, but
Then
that,
what else do you want?
no, that should be correlated with the, my lord, test reports, my lord.
Why?
My echo card is supposed, my lord.
Echocardiography report is there.
Yes, that is normal, my lord. Only BP rise cannot be rejected, my candidate. That may be because
Are
of
you telling
excitement.
me that you are able to read the graph in the ECG?
So that is not, I'm saying, my lord. If suppose BP is, suppose echocardiography report is normal, my lord. Other test report is
It is
normal,
not
my lord.
normal. That is what they are saying. Systolic hypertension.
But they have written systolic hypertension on the ground of, my lord, BP rise, my lord.
Yes.
That
Only on BP rise.
That is the ground.
That is the only.
Hypertension is blood pressure.
Yes.
Yes, my lord.
Yes.
But guideline says, my lord, it should be
That-
correlated, my lord.
No,
That
no,
may be
that is
because of excitement, my lord.
That is
That may be
omitted.
because of excitement, my lord. So
No,
guideline says.
you can't be excited for 3-4 days, no?
Yes, yes.
You can be excited for
That is
one
true, my
day.
lord. But
half an
guideline,
hour.
I am on the guideline, my lord. Guideline says it should be corroborated, my lord.
No,
It is
that is the example.
It is corroborated.
And there was no cardiologist
You
also,
are-
my lord.
You are,
Kindly see, my lord.
you are asking a review of these medical reports on
Yes.
what basis? On the basis of a report given by civil hospital?
Yes,
By a single.
In the civil hospital, were you admitted?
No.
No, my lord.
No.
As OPD patient.
Was there, is there in the report of the civil hospital, is there any corroboration? That
No.
because of these tests undertaken, we find that.
In the civil hospital, blood test report is found to be normal, my lord.
Blood test does not indicate hypertension.
But in the echocardiography report, it is not says it is, my lord, any problem is there, my lord. There must be a report, my lord, at least, my lord.
No, that is what we are saying.
Yes, my lord.
It is a question of a doctor saying yes or no. The final opinion of the doctor is reflected in the
Rejection
in
that
the
is rejection.
opinion.
Yes,
Medical opinion.
Yes.
Now that opinion may or may not have direct reference to the reports. It may not be a detailed report saying that the blood test indicates such and such, ECG indicates such and such. It's not necessary.
But
This
as
is
per
given in a
guidelines,
standard
it is
format.
necessary, my lord. As per guidelines, it is necessary, my lord.
Guidelines is necessary provided you challenge it. You
That
show
were
us,
not challenged.
you show us from any medical test that your medical test undergone immediately thereafter reflects a completely normal status. Where is that?
My test is immediately, my lord, 23rd minute.
Only as an OPD
No.
without
Yes,
admission,
there is
no ECG.
We don't.
But the reports, my lord, they carried out, my lord. That should be, my lord, clarified whether the reports are normal or not.
Counsel, how will you
Systolic
try,
hypertension.
for that matter, know what is the corroboration? It is only for a medical doctor to say so.
Yes, my lord, that may be sent to the, my lord, GMC
Send
also,
to
my lord.
whom?
Because to GMC also, my lord.
Why?
Because my guidelines say,
You first show us that the medical reports on which you are relying on asking for a review are corroborated. Show us. Show us that the test undertaken in GMC is corroborated in the medical report and it says you are normal.
yes, that is not done.
That is not done. Then on what basis you are asking for a review?
I am saying, my lord, they have violated the guideline, my lord.
No.
That is my case, my lord.
Even if you want to make this statement, you have to show from the reports of medical examination which you have undergone to say that in a civil hospital, this is how the reports are prepared. And this is how the doctor has arrived at a finding that I am normal. This is not done by the Composite hospital. Therefore, it calls for a review. The report which you are relying on is a report of a doctor in an OPD.
Yes.
You are not admitted.
Not
Some blood test reports are there. If the report does not indicate that because the parameters in the blood tests are within normal, you are not found to be a patient of hypertension. Is that the finding? No.
That is not finding. But in that my opinion, my lord, there was no cardiologist, my lord. Cardiologist is required, my lord, because my lord, it is hypertension.
Not necessary.
Not
Who will find out, my lord?
Cardiologist is when you have a heart disease. You don't have
That
a
is
heart.
related to, my lord, blood pressure also, my lord.
No, no.
Blood pressure is not by cardiologist.
But my case is, my lord, this is violation of, my lord, guideline, my lord. If report is normal, my lord. Suppose if report is normal, then, my lord,
Which report is normal?
they have carried out, my lord.
Huh?
That report, the investigation carried out by them, my lord.
Investigation.
Since they have not corroborated, my lord.
You are
correlated.
No, it is not corroborated because you have to show us, because you see, a doctor writing that yes, you are not fit or unfit will have to be accepted to be a corroboration.
But now my submission is that since report is before your lordship, my lord, the lordship may send the report to the expert, my lord.
Why?
If they see that all the reports are normal, my lord,
If
they cannot reject me.
Today you are appearing in this matter as a counsel,
yes,
don't just as a matter of example I am giving you. You have told your client you have a good case. You give this to some other person, you give it to Mr. Dhor, you give it to Mr. Adhikari. They may have a different opinion.
They may have, my lord.
So therefore, an expert on the same material may not render uniform findings. In order to come to a conclusion that the Composite hospital did not follow the guideline, you must bring it, you must challenge it by way of some materials which you have independently acquired by putting yourself to examination before a civil hospital in the same format. It is not done.
That is not done.
Then
That is not my case is they have violated the guidelines, my lord. That is my case, my lord.
they have
6B, my
that
lord.
they have violated the guidelines.
6B, my lord, can you see?
No, how they have violated the
6B,
guidelines?
my lord,
6D
is 130.
should be corroborated with confirmatory tests
Yes, my lord.
What is the meaning of corroboration? You must say that the ECG report is normal. Can you say that?
That is why, my lord, the doctor can say, my lord.
Doctor has already said.
Not said, my lord. In the report, it does not say. Only says BP is high, my lord. Only BP is recorded. What is the report in echocardiography report? That is not highlighted, my lord. At least that should be done, my lord.
When it is, there is a doubt, in case of any doubt, here it is clearly mentioned in guideline, lordship. Review medical board may obtain opinion of concerned specialist or super specialist of government medical college and hospital in case of any doubt. There are no doubt, lordship.
In page 42, lordship, it is written, candidate was admitted in CH Guwahati for 3 days for BP monitoring. 3 days BP monitoring revealed systolic hypertension.
Systolic hyper. That is the ground.
That is the ground. It is clearly
Only
reading
BP
was
monitoring.
there.
The rejection, my lord, says.
Let us take your submission that your ECG report is normal.
Yes, my lord.
Hypothetically normal. Will it rule out hypertension?
No.
Then reason should be find out, my lord, as per guideline, my lord.
If your ECG is normal,
Yes.
does it automatically lead to a conclusion that your hypertension is normal, is within the permissible limits?
You should again examine him, my lord. Because the guideline says it may be because of excitement, my lord. That is also
For
there.
3 days. 3 days you are admitted
In the hospital, maybe, my lord.
You don't deny that. You don't deny that.
But guideline says, my lord, I am not saying, my lord. Guideline says it may be excitement because of excitement, my lord.
That is as per
That's why,
example.
that's why he
See,
was
if you,
kept for
if
3
you
days.
can get, if you could have brought materials to say that the same tests were done in a civil hospital and this is the report which says I'm normal. Yes, then we would have sent it for a review board. You have come with a medical opinion that your BP.
Some blood test is there, but the echo is not there.
Even the blood test is not as per, if that.
Blood test is as per guideline, my lord.
If that guideline is to be, according to you, is required to be interpreted, then the blood test is not corroborated in your medical report.
Not.
Then no ECG was done according to you.
Yes, ECG not done.
Then
Blood
on
test
what
is-
basis?
Lipid, cholesterol and aspartame
On
is
what
there.
basis? The doctor has tested your blood pressure just once or maybe twice in the same day.
But
On what
on
basis
the
do
very
you
next
say-
day, my lord. On the very next day, my
On
lord.
the very next day. You may have been very excited that you are going to get a job in this force that may have given rise to your blood pressure.
Yeah, that may be there. That is why, my lord, that is why, my lord, reports should be corroborated with them, my lord.
Mr. Counsel, we are asking you one thing. This corroboration, the fact that these reports are not corroborated, has to be led by you. You have to show
that
the non-corroboration of the report has led to a wrong medical finding. Do you have any materials to say that?
That is not done, my lord. That is not done, my lord.
Then you should have gone for an extensive medical examination to find out.
That was not done, my lord.
Yes.
But your lordship also disposed of earlier occasion, my lord. Some matters, my lord, referring, my lord, the matter to the authority, my lord.
Lordship, in this case, we are filing the review against because the amended guidelines was not before your lordship at that time.
The amended and pre-amended say the
Because
same
they-
thing.
Same, but there are some pages are omitted from the old guideline, lordship. Here, lordship, already review medical has been done in that case, lordship, but lordship had asked to to file a application for review medical again. Here review medical has already been done. After rejection, he has come.
That case was also same series, my lord. In this series,
Yes,
it was there, my
but
lord.
it was disposed of. What we are filing?
Where reports from Fakhruddin Ali Ahmed Medical College was there, my lord, by the petitioner, my lord. Regarding hypertension, Bahul Islam case also there.
Irrefutable the provision. The power. Number.
621417. 1417.
62.
But that is what we are asking you, that where are your independent medical reports to compel us to direct the respondents to go for a review?
Bahul Islam, that is only BP reviews or there.
This is not a binding precedent.
That is true, my lord. Your lordship will consider, my lord.
Binding precedent.
Not binding, but your lordship will consider.
This is in the facts of that particular case.
Yes, ma'am, that is true, my
It
lord. But
doesn't lay down any
the
proposition.
lordship may consider, since BP also was the, my lord.
Maybe, but you see, here you have been examined, you have been admitted to the hospital.
Yes.
You do not have any materials to show that these test results are totally contradictory to the test results available in the undertaken by you in a civil hospital. Nothing like that. Your only ground is that the medical report does not refer to the tests.
Yes.
That will not be a ground to go for a review medical board. We'll do one thing. We will permit him to undergo a test in a civil hospital, whatever tests. By being admitted. And if the report is contrary to the report, he will approach the authority for a review medical board. You conduct a review medical board. Or you consider his claim.
As per the guideline, after review medical board, there shall not be another review medical board, lordship. Our guideline says so, lordship. That will open the floodgates, lordship.
Because therefore, your medical board has to be a little more inclusive. You must include civil doctors, specialists, who Why are you only having CRPF or the
Because the
forces
condition,
doctors?
what required for our paramilitary forces, that was known by
This is a matter of recruitment. It's not
Yes.
just promotion or downgrading somebody into the, in medical category. This is an open advertisement, recruitment process. So there are bound to be a lot of heartburns for people who are not selected. Yes, on these facts, we are not inclined to allow the writ petition.
But your lordship may direct to re-examine the petitioner. In another case, my lord, this honorable court, my lord, direct the petitioner to examine in the GMC hospital, my lord, and sort report from the GMC hospital. Another case, honorable
You're
court.
not getting the point. For us to doubt the report of the services hospital, we need some material. Why should we doubt their competence? They're also doctors. They're also qualified. They've given a
Not
report.
only because, my lord, the impune rejection does not indicate anything about the reports, my lord. That is, my lord, nothing indicated in the
in the
impune
rejection, it
rejection.
is reflected due to.
Only BP is, my lord.
Yes.
Nothing is recorded, my lord.
This is the ground of rejection. That candidate has been admitted in so-and-so hospital for 3 days for BP monitoring. And it was systolic, found systolic.
Where is that guideline again? Revised guideline? This one.
In the ABTV, my lord.
Where are the, where is it provided for blood pressure you are to be rejected?
Page 7. 6. Para number 6 sub para 1. Number 6. Oh, yes, it is. General government. Hypertension. 127.
Page 122, Lord.
Of our epidemic also. With hypertension.
General ground of rejection. Indication of the chronic diseases like tuberculosis, syphilis, or other venereal diseases, rheumatoid, and any type of arthritis, hypertension, etc.
Where is the complete guideline?
Yes.
Not so great.
Why don't you give us a complete guideline instead of different pages?
7.
Just given an order of Supreme Court Lordship, Honorable Supreme Court, here Lordship just says, Lord, in view of the peculiar facts of the present case, we are not inclined to interfere with the impugned judgment and orders. However, we must observe that normally, as a rule, the decision taken by the review medical board in the cases should not be treated, should be treated as final. Recording the aforesaid that special petitions are discussed.
Now first went to these, another set of guidelines are revised.
No,
Page
Lordship,
127.
only omitted the page numbers from their Lordship.
Some page numbers.
Some pages are omitted.
Which pages are omitted?
Lordship, I will give it.
Page 52, 53.
Initially, what was the finding of the medical board, medical doctor?
Initially, Lordship,
BP, my lord, where is BP?
BP.
BP.
No. First,
Yes, my lord.
what,
BP.
where is the report of the first?
In this report, it is reflected, my lord. Yes, 50, my lord.
Page?
Yes, 50 in my requisition, my lord.
50.
50. Reasons for medical unfitness.
No. We are not asking that. This is by the medical board, review medical board.
Review medical board. But that was referred, my lord. That is referred, my lord. The original.
Where is that?
here it is, Lordship. Detailed medical.
So after this medical test, there was a review medical test.
Yes.
Yes, that's.
And with the consent of the petition, as per new guidelines, it has to be consented by the petitioner.
They have followed the procedure.
But
They have
in
followed the procedure.
Your lordship will consider the orders I refer, my lord. Your lordship will consider, my lord. Your lordship order is there, my lord.
Where is that order? Here is a case where they have already undergone the test in the GMC. And thereafter, the claim was for a review medical board. In this case that you're referring.
Review medical board rejected, my lord. Same. In that case, also review medical board rejected, my lord. This case also in the series of this adult, my lord.
Here, what is your document? Only the report and the medical opinion and blood report.
Yes.
Then on what basis, on that basis, how the review medical board will constitute or consider?
They also, my lord, in the input, my lord, they have not said me to your other report is, my lord, some defect is there. No, that nothing was communicated to me, my lord. So how can I will done all the test, my lord? They have not communicated. They have only cited the high BP, my lord. Systolic BP, my lord. Nothing was communicated. That is why I was saying my BP, my lord.
Where is the composite hospital here?
Where's CRPF?
9.
9.
But if you are granted, then everybody else will have to be given a second, third, fourth chance.
Lordship.
That is
That
normal,
is-
but in
that-
some other cases also this honorable court allow, my lord. There are a number of cases, my lord. I'm not placing all the case. My lord.
No, all right, if you had undergone the detailed procedure,
My lord.
which you say the review medical board ought to have done.
Yes.
If you had independently undergone it before a civil hospital,
Yes.
then you have some materials.
That is true, my lord, but they have not informed me, my lord.
They have not.
They only supplied me the copy of the input rejection, my lord. That only says, my lord, BP is high, my lord. Other thing not reported to
No,
me,
but
my lord.
what is your material to go for a review now, except for the opinion and the blood report?
Yeah. That was also, my lord, that is only they have cited in the, my lord, input rejection.
No. You want to go.
Your
for
lordship
a-
is correct, then your lordship is correct. Material
What
is
the
not there,
material
but
now?
since they have cited only, my lord, BP is high, so I have said that only, my lord. If they say, my lord,
It would
your
not be
eco
sufficient
report
to
is
direct
supposed.
a review medical board. That will not be sufficient to direct a review medical board because the procedure laid down in the guideline is very detailed.
Yes.
You have not undergone that procedure in the civil hospital.
That is not undergone, but my case is that they also, my lord, not cited the reasons, my lord. At least they should cite, my lord, this is your problem, my lord.
What benefit do you get out of it?
I can rectify the, my lord, I can test again, my lord, and to rectify the disease, my lord, if anything is there, my lord.
You can go independently. Why do you have to wait for their opinion?
They have not cited anything, my lord.
You go independently and get.
Independently, I have go, but that is found normal, my lord. That is the reason cited, that is found normal, my lord.
The procedure is different. Here you have admitted in the hospital. Here you have OPD patient and taken
No,
one.
he says that he's gone as an OPD. When he's found normal, why should they be hospital admitted?
Because our opinion clearly says he is admitted for 3 days and after taking the BP, he was found systolic hypertension. It was clear in our opinion.
You go for a review medical board in the presence of a civilian specialist. And if the opinion still remains the same, the earlier opinion will sustain. If there is a change in the opinion, consequential orders will follow.
If Lordship this, then other case, Lordship.
They come. It is the procedure that you have.
We have
adopted.
we have followed our guidelines, Lordship.
We are not questioning that you have not followed.
Lordship.
You see, people will always have people will always face hardships in cases of rejection. So you are rejecting not on any other ground except medical ground. And that to hypertension.
This is the condition required in paramilitary forces, which is main concern, Lordship. Medically fit, he or she should be the medically fit.
Your report does not indicate that this hypertension is not related to chronic disease.
But Lordship, as per 6.1, Lordship, it was the ground of rejection, Lordship. The ground of rejection, Lordship. It is general ground for rejection. One.
You listen to the order first. Heard learned counsel for the parties. This petition is filed by the petitioner. Challenging where is the impugned order?
Is 49 minutes.
Challenging the impugned order dated 21/010/2024, whereby the petitioner was found to be unfit on account of, within quotes, systolic hypertension, page 49, and rejected for appointment to the post of a constable GD in the CRPF. What is
The
this?
Central Armed Police Forces.
Huh?
Central Armed Police Forces.
But this is by whom?
By CRPF, but post is Central Armed Police Forces.
All Central Armed Polices are medically undertaken, examined in CRPF.
Some of them are different. Some of them are CRPF, some rifles.
So his assignment was not issued.
Not yet.
For the post of Constable GD in the Central Armed Police Force. So petitioner is agreed that his rejection on the ground of suffering from systolic hypertension is contradicted by a report of a doctor of a civil hospital, which reflects that the petitioner is perfectly normal. Stop. The counsel for the petitioner submits that the guidelines which are laid down by in respect of medical examination in these cases have been flouted by the respondents. There is no corroboration with the clinical findings, and there is no corroboration of the clinical findings with the confirmatory tests / investigations / opinions of specialists / super specialists of government hospitals, medical colleges, etc. Stop. Learned counsel therefore submits that the respondents be directed to examine the petitioner in a review medical board constituted and thereafter give specific reports after due corroboration with the clinical tests that are required to be undertaken. Better. The respondents have contested the matter by filing their affidavits. The respondents submit that the guidelines for review medical board relied upon by the petitioner has undergone amendments. In the amended guidelines, one of the ground for rejection is shown to be hypertension. So the petitioner was duly examined by the medical authorities. In which the medical doctor of the Composite Hospital, CRPF, has returned a finding that the petitioner is unfit for being appointed in the post of Constable GD, as he is found to be suffering from hypertension. Stop. This was followed by a review medical board, whereupon the petitioner was admitted to the Composite Hospital for 3 days, and his blood pressure was duly monitored. And the medical report reveals that the petitioner suffers from systolic hypertension. Stop. The medical report indicates the blood pressure readings for the 3 days. Stop. There was proper ECG undertaken. And blood test also? No.
Yes.
Blood test?
Yes.
And the required blood tests. Stop. All these reports. On the basis of all these tests and reports, the review medical board had returned an opinion that the petitioner was suffering from systolic hypertension, and therefore he is not fit to be retained as a constable in appointed as a constable in the Central Armed Police Forces. Stop. Correct. Counsel, the learned counsel for the petitioner has also placed before the court orders passed by coordinate benches, where in similar matters, the candidate was referred for review medical board. So, counsel has also referred to a judgment passed by this court in WPC number so and so by the order dated 25/3/2025. Stop. On the other end, the respondents have placed an order of the Apex Court passed in SLP number so and so, where the SLP preferred by the union, although dismissed, it was observed that as a normal rule, the decision taken by the review medical board should be treated as final. Stop. Para counsel for the parties have been heard, pleadings available on record have been carefully perused. The review medical board, the amended guidelines for the review medical examination in Central Armed Police Forces and Assam Rifles are enclosed to the counter affidavit filed by the respondents. The clause 7 of the guidelines lay down certain examples which certain examples which are extracted below, page 130, clause 7, A, B, C, D, E. Stop. As well as clause 8. Para. A perusal of the guidelines and the examples extracted above reflects that hypertension / tachycardia is one of the ground for rejection of candidates. Stop. The medical report and the report of the review medical board has returned a finding that the petitioner suffers from systolic hypertension and therefore his case was rejected. Stop. However, the guidelines referred to by the respondents reveal that in cases of hypertension, the hospitalization report should indicate whether rise in blood pressure is of transient nature due to excitement or whether it is due to any organic disease. Stop. Further, clause 8 reflects that rejection on clinical findings are to be avoided. Any decision on rejection must be taken up with valid clinical findings, justified and supported by corroboratory investigation reports, and if needed, opinion of specialists / super specialists of government hospitals / medical colleges / government approved private medical centers should be taken. It is further provided that where such confirmatory tests are required to be carried out routinely, time constraints should not be there, and for not making review medical examination time bound, all concerned must be informed. Otherwise, proper decision cannot be taken in such cases. Well, having heard the counsel for the parties and upon careful perusal of the pleadings available on report, and also upon perusal of the judgments referred to by the counsel for the parties, the court is of the view that rejection of any candidate in selection, more particularly, or selection of combined examinations like that of selection and appointment to CAPFs are bound to cause heartburns to the candidates who are found to be rejected. More particularly, those candidates who have otherwise successfully cleared. There's a written examination? No.
Yes.
Written examination and physical test.
Yes. So all
And physical test. Physical evaluation. So, in the facts of the present case, the petitioner, there is no dispute that the petitioner cleared the earlier rounds of tests or screening procedure, but was ultimately rejected on the ground of medical fitness. So, petitioner was found to be suffering from systolic, within quotes, systolic hypertension by the medical doctor of the forces, F capital, and the review medical board of the CRPF Composite Hospital. Stop. Although the personnel, although the relevant medical records have been placed before the court for examination, reveals that ECG and blood tests have been conducted in respect of the petitioner, and he was also admitted to the Composite hospital for 3 days for monitoring the blood pressure, and pursuant to which the Review Medical Board opined that petitioner suffers from systolic hypertension. This medical report ultimately does not indicate whether the rise in the blood pressure or the medical conditions stated to have been suffered by the petitioner, namely systolic hypertension, is due to excitement or whether it is due to any organic disease. The cause, the probable cause for the medical condition of systolic hypertension found to have been to which the petitioner found to have been suffered by the petitioner does not indicate in the medical report the probable causes and obligor whether it relates to any particular physical ailment or disease suffered by the petitioner. So this conclusion required to be reflected in the medical report is a part of the guidelines of the Review Medical Board, which have been issued by the central government. Although these can be considered to be guidelines in respect of Review Medical Board, however, considering the fact that the findings arrived at in these guidelines, in the reports of the Review Medical Board, if found adverse, will determine the will determine as to whether the candidate is found fit to be enrolled into the services of a central armed police force. So in the facts of the present case, it is this medical report, the review board, which has led to the rejection of the petition. Therefore, these review medical guidelines cannot be treated to be mere guidelines and are required to be strictly adhered to by the respondent authorities. Under such circumstances, this court considers it appropriate to direct the respondent authorities to constitute a review medical board to re-examine the writ petitioner and give a detailed report indicating the tests which are undertaken to arrive at any finding that the petitioner suffers from within quotes systolic hypertension, quotes close, or any other disease which has rendered the petitioner unfit to be recruited in these services. While there can be no quarrel with the findings and the directions of the apex court rendered in order dated so-and-so in SLP number so-and-so, that ordinarily, as a matter of rule, decision of the review medical board should be treated to be final. However, in the peculiar circumstances as has arisen in the present fact, in present proceedings, it is seen that the guidelines itself lay down the procedure and the parameters under which to undertake the process of review medical evaluation or the evaluation by the review medical board. as discussed above, this procedure has not been found to be adhered to by the respondent authorities. So, since this is a matter of employment in respect of the writ petitioner, such measures as laid down in the guidelines, according to the opinion of this court, are required to be strictly followed and adhered to. So, the exercise directed to be undertaken by the writ petitioner, by the respondents, should be undertaken within a period of 60, 30,
3 months.
3 months.
Lordship, we have 60 days, Lordship.
No, only one.
Only one, that's why.
60 days.
We have to consider.
I thought you will say 30 days or 15 days. No,
No, recently new recruitment process
Is
going on, Lordship. They're
90
reviewing.
days.
Yes, Lordship.
Right, 90 days. Any opinion which is any medical opinion arrived at by the review medical board as directed to be constituted by this order after due evaluation of the writ petitioner, arrives at a finding which is contrary to the earlier medical opinion, the subsequent medical opinion shall prevail, and consequential orders in respect of the appointment of the writ petitioner shall be passed by the respondent authority. So, this order, however, will be applicable only in respect of writ petitioner number 2, namely so and so, as it is submitted by the counsel to the petitioner that petitioner number 1 secure.
Only one petition number.
Only one.
Only one.
Only one.
Oh,
There is another case.
okay. This is only one petition.
One.
Yes, disposed.
This should not be a precedent, Lordship, because of the other matters.
Everything we pass becomes a precedent.
Lordship, then I pay for some time in other matters to file an affidavit, additional affidavit to that effect, whether the reports are corroborating or not, Lordship. Otherwise, Lordship.
What is the point in filing a report? If the report is corroborated, it is evident from the report. If it is not, it is not. How will you improve it by filing an affidavit?
We have the records, Lordship.
Published.
You take back the records
Lordship, yes.
immediately. Yes.
Lordship, in item number 27, the reason
What was this item number?
26.
It was 26.
26.
Yes, Lordship. In 27, the reason of unfitness is identical, Lordship. There it was,
Identical?
yes, there it was systolic hypertension. Here it is diastolic hypertension.
6, 7, 9.
27 it is. I go to 26 as well. And that 7E, they have not followed, Lordship.
Where is the report?
At page 79, Lordship. The type copy, your Lordship will find at page 77. Here, however, Lordship, general surgeon opinion was attached, which says that the petitioner was found clinically fit. At page 77.
70?
7, Lordship. 77. The impugned review medical examination report. Serial number 1 has your Lordship got. And reason for medical unfitness, that is in the DME, detailed medical examination. Grade 3 external hemorrhoids, a raised BP 158/100, 148/96. And serial number 2, brief of review
You are
medical
reading from
examination.
which page?
Page 77, Lordship.
77.
Yes.
Reason for medical unfitness. Grade 3 external hemorrhage is not just, there are two reasons.
No, that is in respect of only detailed medical examination. In review medical examination, they did not find it. At serial number 2, brief of review medical examination and finding thereof. A general surgeon opinion attached. Patient is clinically fit from surgeon side. Candidate was found for was admitted for 3 days in Composite Hospital Guwahati for BP monitoring. 3 days BP monitoring reveals diastolic hypertensive. That 3 days BP report, your lordship will find at page number 79.
And what is this? There are two grounds of rejection.
Yes.
Diastolic and trivial.
Trivial
And
regurgitation.
pulmonary
Arterial
artery
hypertension.
3 grounds.
Yes.
Then
At page 79, lordship may kindly take page 79 for a moment.
yes.
On the left side, your lordship will find on from 11 to 14:10, his BP was monitored by the respondents. It was 120 by 98, 122 by 100, 120 by 100 and 133 by 96. 122. 122 by 96. This review medical examination report was prepared on 17/10/2024 at page 76 before the review medical examination. The respondent sent the petitioner to the GMC Mahagod Lordship. There, the petitioner was examined and his 2D echo, everything was FBS, fasting blood sugar, PP blood sugar, everything was conducted. BP, your lordship will find at right side, on the right side of the 124 by 88. He was clinically fit at the time of examination.
This was on which date?
On 17/10.
And the review?
The review was also on 17/10.
Oh. Then how? These are two contradictory.
And since 11 to 14, his blood pressure was monitored. But if your lordship peruses
But in GMC, you were not admitted.
No. He was taken to GMCH.
By the
By
respondents.
the respondents. And that report they did not consider because the guidelines specifically prescribes that the report of the specialist has to
No, tell us one thing.
Lordship.
You were admitted in the composite
Composite
hospital for 3
hospital.
days.
Yes.
Then they examined you first and taken you to
GMCH.
Or they have taken
They
you to
examined
GMC?
me at Composite Hospital for 3 days, from 11 to 14. They found they monitored my BP, and then on 17/10 they had taken me to GMCH, and then on the same day they prepared the report rejecting my
Yes,
candidature.
respondents.
Yes. Here, 3 grounds.
Three grounds are there.
3 grounds are there, lordship.
My only limited prayer is lordship 7E has not been followed. They say that 7A has been followed in their affidavits. 7A, if your lordship Perusa says that in any cardiac case like valvular defects, ECG, echocardiogram must be carried out. And 7E, your lordship has already passed an order in respect of 7E. Because once there is an hypertension, you have to be very specific whether it was transient in nature or not. And since your lordship has very well observed that the excitement may be because he had seen man in uniform and he was excited because he thought that he would be also inducted in the force.
The excitement will give you systolic hypertension, not diastolic.
Lordship. But that is what their
You have had diastolic.
that is what their guidelines say, lordship.
No, but what do you make out of this GMC 76?
This was for the surgery department. Professor of surgery has given this certificate.
Okay.
This is the surgery part.
No, it says registrar of medicine.
No, medicine, lordship, OPD medicine.
Medicine.
Raised,
It's signed by the registrar of medicine.
Signed. Surgery, register of surgery, Guwahati.
Huh?
Signed by Registrar of Surgery.
Page number 76.
From this record.
Lordship, from our record, Lordship.
No, you see page number 76.
This was not. Myram Johan.
This is
Ramkriti Chauhan.
Ramkriti Chauhan.
ठीक है इसने नाम
But this from ours
From our record, this is.
in this is
Positive
different.
होना
Lordship.
चाहिए पहले का तुम बोली ऐसे नहीं
GMC.
Medical courses.
Our report says, Lordship, it says from the surgery, but this doesn't tally with that.
No, surgery is indicated in your composite report, medical report.
Yes.
If you look into page number 78 or 79,
This is our rejection, Lordship.
Rejection.
this is your rejection.
Rejection.
So where is that medical report you had given earlier?
এগুলা পিছত বাকিগুলা পিছত In fact, Lordship, from page number.
If you look into 77, page number 77,
Lordship.
serial number 2, Roman 1,
Roll numbers.
there was a surgeon's report. Is it that surgeon's report?
Yes.
Surgeons had to say.
But 76 is not available in your record.
No, Lordship.
No.
Patient, that surgeon's report is.
Yes, they are lots.
That surgeon is the surgeon of the Composite hospital, I think.
No, the
No,
GMC.
GMC.
GMC. All right, but the 76 is, he says he was taken to GMC. And
Because on 17/10, I was with the respondents inside the
Right.
Composite hospital and they had taken me to the GMCH. I cannot simply go to GMCH and take this report. And in fact, the report which the respondents are now referring, it also says the surgeon's report is, it also says that I was found clinically fit at the time of examination.
which one?
The surgeon's report, which my learned friend is now referring.
Surgeon's report has already declared you fit.
Fit, exactly.
Means that there is no surgical issue.
Lordship.
Yes. Registration number is also different.
And that report was prepared after the 2D echo was conducted, which was as per the 7A and 7E also. 7E they did not follow.
9584.
Now they say that 7A was not followed, 7A was followed and therefore there is no requirement of 7E. And in fact, after the rejection, Lordship, he has again gone to the GMCH from page 80 to 88. In GMCH, he had undertaken blood test, all other tests, which is required to see his why he was found to be unfit. And in all those reports, he was found to be within the normal range.
Yes, 76.
76 is not with our record. It is different.
You are not denying it in your affidavit.
Same number.
You examine, and
Lordship,
tell us.
we have to take.
Let them examine and tell us.
Lordship, it was at 1410. This
No, it was 1710.
14, in our record, it
Okay.
was of 1410.
It was examined in 10. 27.
Otherwise, also, Lordship, a simple order from your Lordship will solve the issue, Lordship.
What is that simple order?
The last, in item number 26, what your Lordship has also.
No, we'll have to be satisfied that
Lordship.
there are 3 grounds of a rejection.
Lordship.
3 grounds.
Lordship. I understand, Lordship.
So the other 2 grounds also will have to be looked into.
Lordship.
Yes,
Obliged.
27 deferred.
My lord, mine is 28.
28. What is your defect?
My lord, the grounds of rejection is, my lord, Morton's toe. The Morton's toe is basically the second toe is longer than the big toe, my lord. So that is the ground here. My lord will find the DME at page 83, my lord. Detailed medical examination.
Page
83, my lord.
Yes.
So Miss Musumi Devi, roll number so and so is hereby informed that she has been medically examined for recruitment at a post of city and so caps at so and found unfit due to the reasons mentioned below. That is Morton toe. It's bilateral, means in both legs. And thereafter review medical was also done. My lord will find at page 86. Same, my lord. Same region, my lord.
Now, what is to be?
Yes, my lord.
Why are you agreeing?
So my agree. If your lordship ever look at the general grounds for rejection, there is nothing that Morton's toe can be rejected. The person having Morton's toe can be rejected, my lord. If your lordship ever look at the revised guideline, my lord. Revised guideline at page 7, my lord.
So there is a list of deficiencies.
Yes.
Where is that?
My lord will find that the general grounds for rejection, the list, my lord. At page 7.
Page 7.
In the guidelines, my lord. Guidelines page 7.
Guidelines page 7. Guidelines.
My lord, I have not annexed it, I have given.
27.
Oh, you
My
have
lord,
the next six.
The guidelines.
Guideline খন তাতে আছে, did you?
27. 27 to 4. Page number 27.
Yes, this is page number 7.
Yes, my lord. This is guidelines for recruitment, medical examination in Central Armed Police Forces. Revised guideline. Page 7, the general grounds for rejection, my lord. So in that case, serial number 22 is there regarding foot, my lord. Deformity of feet like flat foot, club foot, plantar warts, etc. No mention of Morton's toe, my lord. Next, regarding toe, my lord. Next page, minor acceptable defects are also there. Serial 7.7, serial number D. Mild hematose, if there are no painful corns or bursae on the dorsum of the toes. So mild hematose is also acceptable. And this Morton's toe is not a deformity, my lord. It's an anatomical variation, basically. So it can be rejected unless and until there must be some deformities of toes acquired or congenital, including but not limited to conditions such as hallux valgus. And if it prevents the proper wearing of combatized footwear, then it can be rejected. But there was no opinion. The opinion was in short, my lord. There was no opinion that whether combatized footwear can be wear or not with Morton's toe or not. There was no opinion in that regard. Simply saying Morton's toe, it's not enough, my lord.
No, we don't find it here. It's not here.
My lord, page number 104 of my affidavit in opposition. This is page 27 of that guidelines, lordship. Page 20,
104.
internal page 27 and my affidavit 104.
Yes.
That guidelines with B, foot and ankle. B, presence of deformities of the toes, acquired or congenital, including but not limited to the conditions such as hallux valgus, hallux versus hallux rigidus, claw toes, overriding toes that prevents the proper wearing of the combatized footwear or impairs walking, marching, running, or jumping are disqualified.
No, but where is the finding?
Finding, lordship, in the report, lordship, X-ray report done by us, lordship, it was a bilateral Morton process.
Page number?
Lordship, it is in the report, lordship.
This is what he says it is.
Yes.
But that fact that it prevents the person from wearing combatized
footwear.
This is the that was not the deformity. We have review medical board says by Morton toe, which prevent him from.
Where is that finding?
That was.
That finding is not here.
But the deformity is in the guidelines, lordship, which is the guidelines deformities of the
Guidelines don't
foots.
say so.
Lordship, deformities of the foots which prevent
No, first thing you have to say that this is the deformity.
Lordship, we have says the deformity is the Morton toe is there.
No, guidelines do not refer
Yes.
to Morton's toe.
Lordship, deformities of toes, Lordship, can you see page 27, Lordship?
Deformities of toes are there, but the fact that Morton's toe is a deformity,
Lordship.
you have to come to a conclusion somewhere. Either you refer to medical text or some authorities to show that it is considered to be a deformity in medical terms. Then it is one. Or it is not a deformity otherwise, but it comes in the way of wearing
Presence
combatized
of
toes.
deformities in the toes are there, Lordship. B, presence of deformities of the toes.
Mr. Counsel,
Lordship.
whether it is a deformity, you have to first establish it.
Lordship.
What is the meaning of a deformity?
Lordship.
So it's an anatomical variation, my lord. And the Statue of Liberty has also a Morton's toe, my lord. But from the fact, my lord.
I did not have the good fortune to go and see
My
the.
lord.
You may do it on our.
No, my lord, I have searched it in Google.
No, you should do it. You must do it and enlighten us. Yes.
Sometimes whether it is deformity or not, but it is a fact that it was not reflected in the rejection list, but only Morton 2 is there.
So it should go back. Why? What is the point in now?
Lordship,
keeping
if it is the deformity, one of the deformity, Lordship, then Morton 2 is one of the deformity, then our rejection is rightly rejected, Lordship.
No,
My lord, where it is
not-
mentioned.
It is not just deformity. You will have to say that prevents proper wearing of competized footwear.
Yes.
So mere deformity will not help you.
Lordship.
You must come to a conclusion that it is deformity and it prevents wearing of footwear or impairs walking, marching, running, jumping, etc.
And my lord, had there been a deformity, my lord, she had appeared in physical eligibility and she had qualified itself. My lord will find at page 81 in running.
No, but running you are not given competized
Yes,
equipment.
maybe.
You will be given combatized equipment and then undertaken
There
the
might
physical
be.
training.
So there might be there may be some opinion. My lord. There must be some opinion.
Yes.
Lordship, that is true.
All
Leave
right,
it to
heard
Lordship.
counsel for parties, this petition has been filed by the petitioner aggrieved at a rejection for selection and appointment to the post of CAPFs on the ground that she, on the medical, on the ground of having rejected on medical grounds. So the medical opinion of the review medical board reflects that the petitioner has, within quotes, Morton Stowe, MORTON apostrophe S TOE, in both her feet. And that was considered to be a ground for rejection. So counsel for the petitioner submits by referring to the guidelines of review medical board issued by the respondents that Morton Stowe is not enlisted as a deformity, and therefore the petitioner's rejection on the ground of having Morton Stowe is unjustified. On the interim and the rejection order should therefore be interfered with. Whereas Mr. S.S. Roy, learned CGC, appearing for the respondent, submits that he would like to obtain instructions as to whether Morton Stowe is considered to be a deformity in the foot or ankle, and whether it interferes with wearing combatized equipments. So let these instructions be placed before the court on the next date fixed. Please take back the reports.
My lord, next date.
We'll give you a date.
My lord.
Yes.
Much obliged.
Huh? Oh, money? No, separate. Yes. Oh.
Much obliged.
What is that IA for?
I was basically the earlier they have violated the interim order, my lord. That's why it was for.
Is it pending?
Pending, my lord, may dispose it of or
IA so and so filed by the petitioner is not dismissed.
My lord.
Yes, rest of the matters.
Lordship, this, my item 40 is similar to item 28, Morton Stowe.
So what you do, Mr. Roy,
Lordship, I take it,
is that you go into these aspects of finding out Where is the deformity?
Lordship. Check it out, Lordship.
Mine one is that skin disease white spot in Assamese we say that sum paradox. So it was forwarded by the item number 31. It was initially it was forwarded the person from DSF, they have accompanied me to the GMCH. It was forwarded by them, then in the GMCH specialist it is said it is a treatable disease and it can be cured and it is he is fit for physical duty. Then in the review medical evaluation, they have rejected that by saying in the affidavit it is said that we also find that it is rejected by the GMCH. No, GMCH says lordship clearly stated-
He had the deformities. Our question is at that review medical boy, he had the deformity. It may be curable, but it has the deformities. It is admitted. GMC also admitted that there is a disease he is having.
We'll keep it for some other day.
Lordship.
Yes. Let it come in. These matters will be listed again on 9th of September.
On the rest.
9th of September. Mr. Chanda, you also have a matter in the series.
No, my lord, item 51.
No,
If
we
a
are
date
only,
is given
we
by-
are only concerning ourselves with the series for the time being. Not the other matters, only the series matters.
Obliged.
These series matters will be listed on 9th.
9th September.
9th September.
All of the other matters in the.
All of the other matters, except the two disposed ones.
Lodge.
All right.
Item 48 and 29.
Lordship, in this matter, I'm paying for a short adjournment. The matter may be taken up on Tuesday.
Tuesday.
Yes,
Tuesday?
Tuesday.
All right. So
Obliged, Lordship.
joint request list on Tuesday.
Obliged, Lordship.
Item 49 and 50.
May I accuse your lordship? The matter pertains to the upgradation or promotion from grade 4 to grade 3 post my lordship. The petitioner was appointed in the year of 1990 my lord. Thereafter, as a grade 4 employee in the public health department. Thereafter, his service was regularized in 1/11/1999, and he was posted in Udalguri PHE, and he has been continuing in the same department till date. On 2004, my lord, one of the junior most person who was junior to then your petitioner, he was promoted to the grade 4 post, and being aggrieved of that, the petitioner filed an approach before this honorable court by filing a writ petition, my lord. And after hearing the matter, this honorable court disposed of the writ petition with a direction to the respondent authority to pass an appropriate order considering the grievance of the petitioner. And after that, the respondent authority, that order was in Annexure 4, page 17, my lord.
You are asking for promotion to grade 3
To grade 3, my lord.
under,
Udalguri Public Health.
is there a service rule?
Service rule, my lord, that they are, at the time of joining, the petitioner is under the state of Assam, my lord. After bifurcation, the petitioner service is under the BTC authority. The BTC authority have no.
Who's for the state health department, BTC?
On last occasion, RB Vora was appeared for last several occasion, my lord.
And thereafter, my lord, after passing this order, the on
Which order, which order?
the High Court order, my lord,
Ah,
and that is on
page 17.
Page 17, my lord.
Yes.
That was passed on 15/6/2011, my lord. And I'm reading so and so. The petitioner is aggrieved by his non-promotion. According to him, the respondent number 5 was promoted to on 16/11/2004, although he is a junior to the petitioner in grade 4 cadre. The time to time, the representation made by the petitioner urging for promotion at par with the respondent number 5 having no yielded any result, he filed the instant writ petition. In the counter affidavit filed the respondent number 2, nothing material has been stated. Only statement made is that although the respondent number 5 was promoted by order dated 16/11/2004, but the same was cancelled on 27/7/2005. Thereafter, again, the cancellation order was withdrawn by the order dated 28/11/2005 on the basis of the order of this court dated 16/11/2005 passed in WPC number so and so. Nothing has been stated in the affidavit as to whether the said writ petition is still pending or order dated 16/11/2005 is an interim order. In paragraph 7 of the counter affidavit, it has been stated that the Director of Health Service and the Joint Director of Health Service, Malaria, Assam are the authorized for promotion from grade 4 to any other grade 3 post. Thus, the real grievance of the petitioner that he has been suppressed in the matter of promotion by respondent number 5 has not been dealt with. In the counter affidavit filed by the respondent number 3, it has been stated that the cancellation of promotion of the respondent number 5 has been set aside and quashed by this court by order dated 16/11/2005 passed in WPC number 6315/2005. Considering the matter is in its entirety, this writ petition is disposed of directing the respondent number 2 and 3 to pass appropriate order in consideration of the grievance of the petitioner. It is found that the petitioner has been suppressed in the matter of promotion. The grievance may be addressed by considering his case applying the principle next below rule. Let the entire accessor be carried out of expeditiously as possible, preferably within 3 months. In case it is found that the petitioner is entitled to get promotion at par with the respondent number 5, he will not be entitled to get any back wages, but his pay may be fixed nationally. Thereafter, my lord, the Joint Secretary BTC issued a letter, Director of Health Service BTC, regarding the verdict of the order passed by this court, and then this court, and regarding the thereafter the director asking for the vacancy position of vaccination and the seniority list of grade 4 staff under the district who passed the HSLG examination for considering the prayer of Sri Bharat Borua as a grade 4 under the Udalguri district. That is Annexure 6, page 21, my lord. The type copy is Annexure 6, page 21. And thereafter, my lord, the Joint Director of Health Service, the submission of list qualified of grade staff and vacancy position. I am reading, my lord, with reference to the WPC number so and so of Guwahati High Court. I am informed that circular a notice to all hospital, PHC, CHC, SD, etc. Udalguri as regard qualified departmental grade 4 staff who are matriculate or pass SSLC examination or willing to serve appoint in the post of vaccination may apply with attested copy all testimony for the post of proportionate. They will have to sit in interview, both written and oral, at their own cost, which will be conducted by the selection committee. On receipt of the application from department, grade 4 staff statement showing names of the candidate, grade 4 present, place of posting, date of joining of in service, date of birth, educational qualification record of present service should be prepared in office. Thereafter, petitioner also the selection committee was constituted and the petitioner appeared before the interview and their name appeared in the select list, my lord. under the establishment of the Joint Director Health Service Udalguri, that is Annexure 9, page 26, petitioner name is appeared on serial number.
Where is this vector-borne disease workers service order?
Vector-borne service order.
Is it available somewhere?
No, my lord, that is not available with me. And after the non-compliance of this order, my lord, the petitioner filed a contempt.
No, we find that subsequently your case has been rejected.
Yes, my lord.
Rejected on the ground that the post of vaccinator is abolished and surveillance worker has been constituted.
Yeah,
Or
that speaking order was passed on 1st March 2012, my lord. But subsequently, my lord, and that on 5/1/2013, after the speaking order, the Director of Health asking for the regarding total numbers of vaccinator posts in Udalguri district. That means that the vaccinator post was not abolished, my lord. And the 9 numbers of vaccinator post was still there, my lord. Still there.
have you made an averment in the writ petition to that extent?
To that extent, I have already filed a writ petition, but yes, I have made a averment, my lord. But the post is still lying. In the synopsis, I have already stated, my lord.
No, not synopsis in the writ petition. Is there any averment?
So I have annexed this vacancy position, my lord. That is why the photo. Yeah. The petitioner begged to state the said vacant gate 3 posts are still lying vacant. The paragraph 8, page 7. Neither phrase recruitment process nor taken any action for promotion or upgradation for existing grade 4 incumbent. On 5/1/2013, the Joint Director Health Service Udalguri BTAD issued a letter to the Director of Health Service, so and so, reference to the letter 19, wherein submit the detailed vacant 9 post of vaccinator under the establishment the Office of Joint Director of Health Service Udalguri for early action. That after that, the respondent authority did not file any affidavit. And lastly, the respondent authority has filed an affidavit where they have stated that is when they have filed, that is not mentioned, my lord. And last affidavit, my lord, that is filed by the respondent authority, filed by the in opposition, filed by the respondent number 4, my lord. They have says in the paragraph 4, my lord, that the deponent begged to state that a meeting of the Departmental Promotion Committee, DPC of Health and Family Welfare Department, BTC, for promotion of staff was held on 15/5/2024. The meeting examined the sanctioned staff strength of various posts lying under the establishment of Joint Director Udalguri presented by him in a DPC and found 6 numbers of LDA and 3 numbers of dresser poster lying vacant, which are promotional from the grade 4 to grade 3. However, in case of dresser post, experience certificate is required from the concerned head of the department of the health institution where he is working. In spite of having vacant sanctioned posts like vaccinator, surveillance worker, NMA, lying under the establishment of Joint Director Health Service Udalguri, and DPC meeting discuss and arrive at a conclusion that the consequent upon the abolition of vaccinator posts by the government of Assam, that this post can no longer be filled up by way of promotion, and so as surveillance workers and NMA, which are made from direct recruitment only in the spirit of speaking order of BTC. In the instant case, for promotion of grade 4 to grade 3, only 1 post of grade 3 can be filled up by way of promotion as per sub-rule 6B of the Assam Ministerial Direct Establishment Service Rules 1967 as per ratio of 90:10. In this regard, the DPC discussed and examined thoroughly as per their qualification and experience of the following lead petitioner of the instant court cases and found that the petitioner Bharat Chandra Borua, grade 4 HSLC found no experience certificate and he is not qualified for promotion. After working last 26 years, an experience certificate is required for promotion. And the third one is Moneshwar Brahma, that is the repetition number 703 of 2018, where Moneshwar Baru, who was a BA pass from Khairabari College under Krishnakanta Hendrik State Open University and rendering service more than 7 years. The DPC agreed in favor of said Moneshwar Baru and thus considered him from promotion to the post of grade 3. That the petitioner in petition number 7194, who was working last 26 years in the same post, my lord, and at this stage, it is experience certificate is required for promotion. That is my case. And
Who's appearing for BTC?
Lordship, let me please.
There is an averment that there are some posts of vaccinators still lying.
But stated the fact lordship vaccinator post is abolished by the government of Assam by notification lordship.
No.
So
She's made a categorical statement in para 8 of the writ petition. We don't find any.
lordship, we are also
I'll look
admitting.
your affidavit.
We have stated in paragraph 35, page 35 lordship. Which I have filed, affidavit in opposition filed by respondent number 4. Internal page 3 lordship. Here also we have stated in spite of having vacant sanctioned posts like vaccinator, surveillance worker and NM lying under the establishment of junior director health service Udalguri, the DPC meeting discussion arrived at conclusion that consequence upon the abolition of vaccinator post by the government of Assam, filed notification dated 489. This post can no longer be filled up by way of promotion.
So are you abolishing these posts or what?
Government of Assam is abolished, lordship.
No, but then if they were abolished, then how these posts are available?
Earlier they are lordship where they are working and some other retired. So this post now cannot be filled up through promotion lordship.
No, if it is abolished, then how can it be filled up? How can you say that they're in existence?
Lordship, this is that post, perhaps that post shall rename after retirement of some vaccinator. That vaccinator post.
No, you come to page 35.
Yes.
The paragraph that you say that sanctioned vacant posts of vaccinator and so lying in the establishment.
Yes, Lordship. But that post cannot be filled up through promotion.
Then how will it be filled up?
Direct recruitment.
No, but vaccinator post is to be filled up by promotion.
Vector-borne Disease Control Act 2000. Vector-borne Disease Control Program Worker Service Order 2006.
Do you have a copy?
I have already submitted before Honorable Court. I think they are Lordship. I think they are.
You have submitted?
Yes, Lordship. Earlier I have submitted.
Yes.
Section, Lordship, paragraph 6, Lordship, substitution of clause 6 in the principal order of clause 6 for the heading first paragraph and sub clause so and so. Direct recruitment. Direct recruitment to the orders of SW, surveillance worker, that means BHW and other grade 3 post under DHS Assam and this Family Welfare Assam shall be made by the appointing authority on the basis of examination made by the board in order to preference in the following manner.
The petitioner already appeared in the interview in the year 2011 and he has already been selected. By ignoring the fact that despite having a High Court order and post has already arrived at the relevant point of time. This is the second time litigation filed by the petitioner before this court. according to Assam Directorate Established Ministerial Service Rule 1973, Rule 10, Sub-Rule 3, there is a provision with regard to the seniority amongst the grade 4 staff who has passed the higher secondary or equivalent examination.
Which service rules govern your services?
Assam, my lord, but BTC have no service rule.
What about this vector-borne?
Vector-borne disease?
This is the service order.
To that effect, we have
But
passed the order, Lordship, annexure 10 of the writ petition, Lordship. Order dated 1st March 2012. Annexure 10, page 27 of the writ petition, Lordship.
Yes, I have.
Where you have rejected on the ground that it is abolished.
Abolition.
And 2012, that order was passed, but in 2013, they have submitted the total number of vacancy position of vaccinator, which is still lying, and nine numbers of vaccination post was lying vacant, my lord. At least one promotion in the lifetime, the petitioner must get, my lord.
You are now employed as?
As a grade 4 employee,
In which department?
Udalguri, Public Health, under the Joint Director of Health Service, Udalguri.
So, what are the grade 3 posts available there?
NMA post is available.
What is NMA?
Non-medical assistant, that is a grade 3.
This is under which rule?
Non-medical, sorry, what? Non-medical assistant.
This is not under vector-borne.
This is not not under the vector-borne, my lord, but still grade 3 post is available.
Where is this non-medical assistant? Where is it? Under what post? Under what rules is it covered? You give us the cadre strength of your department, let us see. Director of Health Service, what is the cadre strength? What is the position? How many posts are vacant?
Lordship, it is stated in our affidavit, but the problem is, Lordship, evolution of the clause. We have stated in our affidavit some.
These orders have been repealed or what?
Lordship.
No, are you saying these orders, these vector-borne disease control service orders have been repealed?
State government.
Huh?
State government has abolished the post.
Oh, that is abolished, we understand. Is there a post called, what is that, non-medical?
Assistant.
Assistant.
That I have to take instruction.
Please take instructions and come out and tell us where these posts are available.
Non-medical.
And what is the service rules governing them? Heard MSA Buzarbura and Council for Parties for the petitioner, MS RP Bora, for the respondents, PTC. And MS Bora will obtain instructions as to the availability of vacant posts in the cadre of the office of under the office of vacant posts in the cadre of grade 3 available under the office of Joint Director Health Service Udalguri. Stop. If vacant posts of non-medical assistant within bracket NMA posts are available, which the Council for Petitioner submits, are also posts covered under grade, also posts under grade 3, then the council or the BTC will apprise the court the total number of such posts available and the manner in how these posts are to be filled up. Let these instructions be placed again after
2 weeks.
2 weeks.
And lordship date may be fixed because petitioner will go on retirement on December 2025.
2nd September.
Second September, third lordship. Okay, third. Lordship.
Second.
Second.
Public.
Item 51.
Yes.
May I please? Okay. Well, this is a case of imposition of penalty of extreme penalty of removal from service, my lord. And the appellate authority also upheld the order of penalty. What happened, my lord? In this case, all other co-accused have been reinstated in service. They were also, some of them were also given the removal order initially by the disciplinary authority, given the order of removal from service. But thereafter on appeal, my lord, out of the same deal, my lord, again, by the appellate authority, they have been reinstated in service with imposition of minor penalty. And some of them have not been imposed any penalty. And this honorable court, one of the co-accused, approves this honorable court. And following the judgment rendered by in Ajendra Kumar versus State of Madhya Pradesh, Supreme Court, Parity in penalty, your lordship. This honorable court also, in a case of co-accused, directed, passed an order to reinstate him in service, given the penalty of compulsory retirement with full pensionary benefit.
And what is the punishment imposed? Dismissal.
Dismissal. In many of the cases, dismissal, and some of the cases, it was modified by the appellate authority. It was modified by the appellate authority.
In your case?
In my case, my lord, it is dismissal from service. Annexure 21, your lordship. Initially, he was dismissed. Initially, he was dismissed, and that was the order. This is a second round of litigation, your lordship.
You have collected some money.
My lord, not only me, my lord. It was entrusted to a group of employees. Lordship, 8 persons. Altogether 8 persons. If your lordship take up annexure 1, your lordship, the DA area was sanctioned by the government of Assam, and this was supposed to be disbursed within a time frame, my lord. So which could not be disbursed, and the remaining amount, my lord, in fact, I must say that it is with the consent of the department, some of the officers of the department. This amount was given in the personal accounts of the employees, so that it should not be lapsed. And this was also observed in the earlier judgment. This was also observed. Lordship will find annexure page 28 of the writ petition. My lord, the preparation for DA and disbursement of DA was ordered by order dated 26 March 2014, page 28, your lordship. The next order, your lordship will find all the 8 persons. Lordship will find all the 8 persons. My lord, my name is at serial number 6, my lord. My name is at serial number 6, my lord.
Yes.
My lord, this ABSI Achut Kalita, then my lord Ashok Bora, all they have been the 8, serial number 8, Mandal, my lord. All they were, again, my lord, imposed minor penalty. The original penalty of removal from service have been modified, and they were reinstated in service. And 2 persons were, my lord, given compulsory retirement.
What is the finding in the inquiry?
Inquiry, my lord, the charge is proved. Charge is proved in all the cases.
Where is the
all the cases, my lord.
Where is the inquiry report?
Inquiry report, your lordship will find page 41, your lordship. It is started from 41. And relevant page, your lordship, 60. In all the cases, the same finding, my lord. In all the cases, same finding. Lordship, relevant page is 58 and 58 and 61. 61. And similar finding is given by the inquiry officers in respect of all the co-accused. Same finding, right? But parity of penalty, that principle has not been followed.
You admitted.
My lord, everyone admitted. Same findings. Your lord. Same finding, everyone, my lord, lordship, if your lordship, the judgment of this honorable court, page, in my...
Which judgment are you referring to for?
Supreme Court. Supreme Court, that is, my lord, lordship will find last annexure of my writ petition, that is page 127, your lordship. 127. Ajendra Jadhav, 2013 3 SCC, page 73. Ajendra Jadhav versus State of Madhya Pradesh and others. Relevant para, my lord. 9, 10, 11 and 12, my lord. Page 130. Page 130, relevant, my lord. May I read this para, my lord? The doctrine of equality applies to all who are equally placed, even among persons who are found guilty. The persons who have been found guilty can also claim equality of treatment if they can establish discrimination while imposing punishment when all of them are involved in same incident. When all of them are, well, this is the word is same incident. Parity among co-delinquents has also to be maintained when punishment is being imposed. Punishment should not be disproportionate while comparing the involvement of co-delinquents who are parties to the same transaction or incident. The disciplinary authority cannot impose punishment which is disproportionate, that is lesser punishment for serious offences and stringent punishment for lesser offences. The principle stated above is seen applied in a few judgments of this court. The earliest one is DG of Police versus G. Dayasan, wherein one Dayasan, a police constable, along with two others constables and one head constables, were charged for the same acts of misconduct. The disciplinary authority exonerated two other constables, but imposed punishment of dismissal from service on Dayasan. My lord, here, my lord, some of them were exonerated, even not given penalty also. Not given penalty also, some of them. The supervisor, as R. Bhattacharjee, he was not given any penalty, my lord. That order I have enclosed in the writ petition itself. I am reading it, my lord. Para 10. This court, in order to meet the ends of justice, substituted the order of compulsory retirement in place of the order of dismissal from service on Dayasan, applying the principle of parity in punishment among co-delinquents. This court held that it may otherwise violate Article 14 of the Constitution. In Shailesh Kumar, Harshabai Shah case, workman was dismissed from service for proved misconduct. However, few other workmen against whom there were identical allegations were allowed to avail of the benefit of voluntary retirement scheme. In such circumstances, this court directed that the workmen also be treated on the same footing and be given the benefit of voluntary retirement from service from the month in which the others were given the benefit. We are of the view that principle laid down in the above mentioned judgment would also apply to the facts of the present case. We have already indicated that the action of the disciplinary authority imposing a comparatively lighter punishment on the co-delinquent Arjun Pathak and at the same time harsher punishment on the appellant cannot be permitted in law since they were all involved in the same incident. Here, my lord, some of them were not given punishment at all, and some of the co-accused, your lordship, given increments, 2 increments down with cumulative effects. Those orders I have enclosed, my lord. Those orders I have enclosed. Then, my lord, we are inclined to allow the appeals by setting aside the punishment of dismissal from service imposed on the appellant and order he be reinstated in service forthwith. The appellant is therefore to be reinstated from the date on which Arjun Pathak was reinstated and be given all consequential benefit as are given to Arjun Pathak, ordered accordingly. However, there will be no order as to cost. Same issue, my lord. In the rejoinder, your lordship, in my affidavit in reply, your lordship, this honorable court passed an order that is page 150, my lord.
151.
Sorry, 151, my lord. In my affidavit in reply. That is Achut Kolita. One of the co-accused, your lordship. My lord.
The order passed.
This order was passed, my lord. 13/4/21. Lordship, page 17, your lordship, the facts of the case.
70, 150.
No, 152, sorry, my lord. Page 152. May I read the para 2, my lord? While the petitioner was posted at 8th Assam Police Battalion, situated at Abhayapuri ABSI, the respondent number 4, who was the commandant of the battalion, issued an order by memo number so-and-so, dated 26/3/2014, by which 8 personnel of the battalion, including the petitioner, were entrusted with the job of preparing the pending DA area. 8 persons, lordship will kindly take a note. 8 persons. DA area bill of the personnel of the battalions for the period 1/1/1998 to 31/5/2001 and 1/7/2002 to 31/5/2005, for which sanction was accorded by the government by the order number so-and-so, dated 5/3/2014, as per the order of personnel entrusted with the job mentioned above, were directed to work under the supervision of Sri R. Bhattacharjee. That R. Bhattacharjee was not given any penalty, your lords. Head assistant of the unit, and they were under his supervision, all these things has been done. He was not given no penalty. In the meanwhile, he has retired, and that order I have enclosed in my writ petition, my lord. Head assistant of the unit, and they were also given the responsibility of scrutinizing the bank account numbers and bill amounts of the personnel, including those who have retired from service or transferred from the unit or expired, etc. Now, my lord, lordship may straightway come to page 27, my lord. No, 162. Yes, sorry, page 162, my lord. Internal running page 162, internal page 27. Here, my lordship will find a chart was given against the co-accused, your lordship. Against the co-accused. Mandal, serial number 1, my lord, name of the incumbent with resignation. In the said judgment, it is quoted. The other co-accused.
The name of the petitioner is not here.
No, because my lord, because they have cited that they have been reinstated in service. Because it was cited, as I am now citing, my lord. It was cited. So, my lord, here your lordship will find Mandal. In the right side column, your lordship, removed from service. In third column, fate of DP, removed from service and present status. By order dated 31/12/15, appellate authority reinstated in service. Then, my lord, Ashok Kumar Bora. He was also removed from service by order dated 31/12/15, appellate authority reinstated in service. Then, my lord, Rasharaj Bhattacharjee, who was the supervisor under whom we are working, severely reprimanded for misconduct. By order dated 17/7/2018, he was not given any punishment, my lord. He was not given any punishment. 17/7/2018, given all service benefit as he retired on 30/3/2016 during departmental proceeding.
Okay, we'll continue next week.
My lord. My lord. Can it be remain as a part of my
list on Tuesday?
Developed.
Yes, rest of the matters.
Item 52, next matter.
Next week.
Here item 55. My lord, and in this case, in my case, my lord, I am not receiving pension, my lord.
You are not receiving pension.
Yes, my
Your
lord.
matter will be taken up on 2nd September.
Little earlier, my lord, because what happened, my lord, without any stay order, my lord, that petitioner was proposed.
28th. 28th of August.
28.
Okay.
My lord, I am for item number 53, my lord.
Also on 28th. Mr. Sharma,
Item 55.
55, what is the matter about?
Matter was that he was not given the retirement benefits and other things.
26?
Well, 26, there are many items fixed, my lord. Can you be 2nd of September?
2nd September.
Yes.
all right.
Obliged.
2nd September.